rent-free in your heads again, huh? I mean, if you're gonna spend your days obsessing over me, you might as well start calling me something respectable. Maybe Daddy Shizzy, or better yet, Papa Nut. Who's the grown-up here? Alright, it's me. Let's go. Call me Daddy, yeah, that's who I am. Running your mind's like the master plan. Papa Nut, Shizzy Daddy, take your pick. I'm rolling in your thoughts while you still act sick. Call me Daddy, it's what you mean. Why you chase the crooks and I take the lead? Living rent-free, that's my name. Go ahead, say it, put some respect on the name. Man, I'm too old, well here's a surprise. I'm the one with the brains while you're stuck with the lies. You act like you're experts, but here's the reality. I'm the one controlling your mental reality. So while you're out there trying to throw shade, I'm sipping coffee and you're feeling betrayed. You're mad, I got the spotlight, now it's my time. So why not call me Daddy or Papa with a rhyme? I'm the landlord and you're just the tenants, stuck in your headspace with no end to sight, no repentance. Call me Daddy, you know it's true. You'd be lost without me, stuck in the glue. Call me Daddy, I'm holding your mind while you're scrambling, trying to find what's behind. Papa Nut, Shizzy Daddy, don't you see? You're living in my world now, I'm a VIP. Call me Daddy, just let it be. While you're trying to figure out your own identity. Oh, I see you're confused, trying to get it right, spinning your wheels while I'm out of sight. You think you've got it figured, but you got it all wrong. I've been running your minds all along. But sure, keep pretending you don't care. Keep saying you're done, but I'm still in the air. You got no choice but to bow to my name. Daddy Shizzy is here to own the game. You say you don't watch, but you're obsessed. Every word I say puts you to the test. Call me Daddy, Papa Nut, you know you should. Because I've been living rent-free, and you know it feels good. Stuck with Daddy for life. I'm Papa Nut, Shizzy Daddy, owning your headspace, and there's no escape. Good luck with that.
Oh, I'm muted. I love whenever I mute myself. Isn't that glorious? Good evening, everybody. How are you? Man, it is another night. And of course, you've got people over there celebrating. They're just like, oh, look, we won. What did they actually win? I guess we'll go into that a little bit tonight, but we can also look at what's happening in the bankruptcy case, which I find a little more interesting. And I would dig into some of the Laura Owen stuff, but I've got a little bit of something that I need to cover before I do that. And I've got something I've got planning for that. And there's another case that I've been following for quite some time, even longer than I've been following the Hale stuff, that is going to be really interesting. And I hope you guys find it enjoyable. But I do have something I want to show you guys really quick, because it is not the final, but you guys are going to get the first peek at it. And so I hope that you absolutely enjoy it, because, well, I'm a fool like that. Sometimes I do things whenever I have a little bit of free time to do them, and I did have a little free time to get this one done. If I can find it here. I know where it is. It is right there, and it is that one there, and I will find it. Here we go. All right, you guys get the first look at it. Enjoy it while you can, because it's gonna get a little bit of changes to it, but this right here is the absolute brand new one, just for all you fine folks. Here we go.
Yeah. Come on. Flea head. Grab a chair, fat ass, you're gonna need it. Let's run your sticky note opera. You start with like that's your whole case file. Blew your feelings to it, call it evidence for a while. Don't fall for lies, finger wagging at the moon while your ass screams. Please believe me, I'm the go where the hell you were going. If he had proof, he wouldn't ask. This comedian gold. Cause receipts don't just appear cause you said something. Yo, shit's getting old. You don't decree reality with caps lock decrees. The next shot when we go cool. Show me, please. Oh, you mad? Sure. Talk too much, you lose. Bluffing hard, you lose. Trust me, win. You lose. That grand, you lose. You lose. You lose. You lose. You lose. You lose. I'm a creditor, congrats. Just a fat ass in the room. Still talk like hallway gossip. Got a tick, tick, and boom. Potential contingent, tossing herbs like shields. Think the court gon' faint cause you spoke in the field. You got my licks already, so which is a stout the click. Can't cry in the fears while screaming, check my heart rate quick. That ain't threat, this meltdown with customer service vibes. Yeah, keep going. Play both sides. You lose. Story slipping. You lose. Posture and plea. You lose. Volume don't make it true. Intuition, you solo psychic show, grilling yourself. Still don't know what you know. Did you do X? No. Why? No. It's Tyler Alibi in the cookie jar, bro. Yelling, it doesn't exist. Loud as hell, think volume makes truth disappear. Now your lives rings fast. Real shit stands quiet. Yours needs vetting, dumbass. That's cute. Swear you clean. You lose. Prints everywhere. You lose. I didn't fool, I heard. You lose. Facts, just stories sold. Spoke true, say the kid. Turn through D's in the blockbuster where you to lead. You say you used it for content. You doing the same dance. Posting updates, name drops, chasing likes in advance. Success with me like flexing wounded one. But you wrote a trilogy about them called Enjoy Your Day, son. Yeah, that's the tale. Real talk, walrus. Receipts don't need theater. You got docs and vids. Lake 'em, let 'em speak clearer. Trust me, jackass. Lake a legal move anywhere. Except fucktard college. You headlining there. You feel that? Talk too much, you lose. You lose. Bluff and clutch, you lose. You lose. Swing for cool, you lose. You lose. Script reading full, you lose. You lose. You lose. Every time, you lose. Every time. You lose. Not scared at all. Scared folks always say that first. Don't think of live like middle school reverse. You sell courage, we see sweat and giggle after jabs. Keep poking fortune, cookie law, announcing what ain't there. Harder you perform, clearer you trying to convince yourself. Not us. You lose. Yeah. Enjoy your day, y'all. Fat ass. Keep laughing. Makes your collapse sound like applause.
You guys are killing me. Is that a man or a woman? I don't know. You tell me. I haven't been able to figure that out myself. Oh my gosh. I hope that everybody's having a wonderful night. How are you doing? Hello, Killdozer. Hey, Shizzy. Hey, Jeffrey. Still can't see well yet. Oh, that's all right. I hope you get to feeling better, though, brother. I hope you get feeling better than Cricket Rockin' since he escaped from the fleas. I'm telling you, you gotta have a little bit of fun, a little bit of laughter, a little bit of fun, and a little bit of laughter. And speaking of laughter, I noticed that the fleas were over there celebrating. Oh my God, the whole Anti-Hale's ecosystem's over there celebrating. They got this big win. Well, there's only one way to handle fools like that, because, it becomes really, really interesting whenever you just shoot down their little fun. It's so bad. So what and Tug ended early. New Bad's kicking his ass. Oh, I can imagine. Hello, beautiful people. Welcome all you Tug Raiders coming in. welcome, welcome, welcome. If you feel like it, you can reach down there. You can hit the Tammy B is in the hour asking for prayers. Holy crap. Oh, hey Tammy, how you doing? Oh my gosh, yeah. Thank you very much for letting me know. Maybe not. Oh man, that's prayers out to you, Tammy. That's no fun. Get to be safe out there. We just know that our thoughts are with you. That's never good. Oh, yeah. Prayers out to you, Tammy B. You I hope that everything works down. Reach down where now, Shizzy and CMA. See, that's sort of weird. That's sort of weird. I'll reach down wherever I want to, damn it. I'm gonna have to rewatch Tug, and it has lots going. Yeah, there is a lot going on today. Trust me, there is quite a few things going on today. Hey, how you doing, Nina Drexter? Good to see you. Welcome, welcome. Hello, hello, hello. And oh my gosh, it is you said it. You said it. You said it, damn it. Good to see you back. Oh my gosh. Oh man. So I figured the best way to do this was just to start out with an open letter, just to show them how bad off they are.
It is about time. Let's break this mother down. With Shizzywhiznut.
Oh yes. An open letter for the champagne at halftime. There's a certain sound a courtroom makes when a magistrate issues a report and a recommendation. It's not confetti, it's not trumpets, it's not the swelling orchestra of vindication. It is the dry shuffle of paper and the quiet hum of federal procedure doing what federal procedure does. Yet somehow across the digital tundra of the self-proclaimed ecosystem, I'm watching people pop imaginary corks like they just hoisted the Lombardi trophy over a 45-page PDF. So let's slow this parade down before someone sprains an ankle and busts their knees on the curb. What dropped was a report and recommendation, not a final order, not a judgment, not a finding that angels descended from Pensacola and declared you righteous. It's a recommendation, a draft opinion, a procedural checkpoint, the legal equivalent of, here's my homework, Judge, you want to look it over? There's still an objection window. There's still review by the district judge. There's still unresolved defendants. There are still pending matters. There are still entire lanes of litigation that are moving in parallel. And yet I'm watching people talk about the countersuits like they just discovered fire. Countersuits on a recommendation before a final ruling. Are you that much of a mental midget? You don't build a victory float at halftime. When the court addressed its pleading sufficiency, structure, element, specificity, the architecture of a complaint, not moral exoneration, not a historical rewriting, not a divine proclamation that everything ever said on YouTube was wise, measured, or factually pristine. The court did not say these defendants are saints. The court said, in essence, this complaint, as written, does not meet federal pleading standards. It's not absolution, that's just formatting. Celebrating like it's a cosmic endorsement is like bragging that your parking ticket got dismissed because the officer wrote the wrong date. Congratulations, dumbass. You did not become a better driver. You just survived a clerical choke point. And the countersuit chatter, well, that's my favorite part. Nothing says we understand federal procedure like planning new litigation while the current one hasn't reached final disposition. That's not strategy. That's just a moron that doesn't understand court procedure. Let's also not ignore the subtle undertone of the recommendation itself. The court described the complaint as sprawling, borderline shotgun, heavy on links, thin on certain elements he wanted to see. That's not a love letter to anyone involved. That's a procedural critique. The judge didn't sing hymns about your commentary. He applied Rule 12b-6. You're celebrating a filter. You've not survived trial. You've not prevailed on summary judgment. You've not defeated evidence. You've not even secured a final judgment. You idiots, you received a recommendation that certain counts as drafted don't survive the pleading stage. That's it. Sure, the anti-slap fee recommendation for one defendant, yes, that's serious. Yes, that matters. But even that is still subject to adoption from a judge and calculation. It is not a fireworks display. It's a statutory mechanism trying to speech protection. So just calm your jets down. The premature chest thumping tells me more than the R&R does. It tells me that some of you desperately needed a screenshot, a headline, a moment to declare, see, we were right all along. But procedure is not prophecy. Litigation is not a free-for-all. It's layered, technical, and often pretty freaking dull, which is precisely why the ones screaming the loudest right now are the ones who mistake a magistrate's draft for a win. If you want to celebrate something real, wait for the final order. Wait for appellate posture. Wait for closure. Until then, you're dancing in the end zone during halftime. And if your legal strategic response to a procedural recommendation is let's countersue immediately, I suggest you at least read Rule 13 before you order the new clown balloons. Because this isn't over. It isn't decided. It isn't final. It's a chapter. So by all means, enjoy your sparkling cider. Just understand that the scoreboard hasn't locked, the whistle hasn't blown, and the district judge still has the pen. With calm hands, Velcro shoes that stick to the floor, better than your legal analysis, most definitely Shizzywhiznut.
It is about time. Let's break this mother down. With Shizzywhiznut.
Do you think that was satisfactory enough? Do you think it was good enough? Hello, welcome all you fine people just coming in and joining us. Awesome video, actually watching live. Always thanks for the giggles. Well, most definitely Ellen's Tank. I appreciate it. I love it. Are the fleas celebrating? What are they're celebrating that there was an order that came in from the judge. It was just a recommendation, and I'll show it to you if that makes a little more sense. What it is there's this thing that came in that's a report and recommendation. Okay, so while they're over there celebrating, this is just what the Judge Belitho has recommended to Judge Hinkle. Now, there's a period of time before this all happens. There's 14 days for them to come back, and they can actually cure a lot of what's going on with this just with a simple filing, because the judge is saying, you know, it's 74-page amended complaint with pages and pages of YouTube links that borders on a shotgun pleading. He doesn't call it a shotgun pleading. He says that it borders on one. Basically, a shotgun, it doesn't meet the standard for a shotgun pleading. If you look up what the standard for a shotgun pleading is, there's only one person in the Anti-Hills group there that's done one of those. Doug had to end early. Oof. I hope he gets the rest that he needs. Oh, Lombardi, yeah, you guys are awesome, man. 122 chats. I got to scroll down through a lot of this. Hey, how you doing? Oh, yes. My gosh. If Hinkle overrules Bolitho, can he remove Bolitho because of this? I don't know what that he would. Because you also have to understand that within the next 14 days, Randy can file something new that basically cleans up any deficiencies that you found. Because if you read through the document, which we will probably read through it a little bit later on for those that enjoy reading through these documents. We'll read through some of it, and if Randy can cure what's going on with this, with what the judge finds as a problem, if he cures that, then most likely the judge is going to say, oh, okay, that makes more sense. You know, we can move forward. I mean, that's really what it boils down to. If they countersued, wouldn't they have to prove original case was brought in bad faith to prove that? Wouldn't basically have to get everything that Jeremy Hills was claiming, prove it wrong, and prove it wrong? Maybe. I mean, you know, you have to understand, before they could do any sort of countersuit, and you have to remember that the amount that they would win would be very minimal. I mean, because what did it actually cost them? So you have to remember, what did it actually cost them? It cost them what? Postage and shipping. That's it. That's really all that it cost them. You know, they didn't hire attorneys. They didn't have any, you know, anybody that was of, you know, that they don't have any attorney's fees, so they can't get those. And that's where most of your money's going to be eaten up. And you would have to look at it reasonably, and the judge is just going to say, you filed a response. If you were stressing over it, that's on you. That's not on the court. It's also not on the plaintiff. So, I mean, they could possibly get it. And also, thank you very much for the $10 super chat. That's very nice. But yeah, there's a lot that has to happen. Plus, you also have to have a final order for them to bring any sort of suit. And then they're looking at who knows how long that they're going to have to fight that out in court. And I don't think they have longevity to do anything of the sort. And you still haven't gotten through Paint Chip's motion and Randy's motion on top of that, which looks like Paint Chips filed another motion today, which that one right there is just basically, you know, the judge is going to review that and probably issue some sort of order on that at some point in time. Read the whole thing, just tells me a lawyer needs to show their entire hand with that magistrate. Well, I don't think so, Peggy. I don't think, you know, here the magistrate is looking at this impartially. At least you hope that he is. Is he? Do you have to agree with what the magistrate says? No, you don't have to agree with what the magistrate says. But whenever all is said and done, whenever this case is finished, that'll be the end of it. I mean, what are they going to attempt to sue for? Mental distress? Oh, I was injured mentally. Well, you were injured so mentally that you jumped on a stream right afterwards and started popping a cork and celebrating. Yeah, that's not going to float with a judge. You know what? So you're going to hire an attorney, to file a countersuit? Well, that'll be interesting, because what happens if you lose? Then you're having to pay an attorney for a countersuit that you lost. Celebrate. Sean Poe is celebrating, though. Sean Poe celebrates 7 months of membership. Hope your birthday and weekend rocked. 65th birthday Sunday. Seahawks win to boot. Happy gal. Congratulations, Sean Poe. That's very cool. Well, and very much congratulations on your birthday. I mean, we love whenever you have a birthday. Yes, you do.
Oh my, happy birthday to you. Happy birthday to you. Happy birthday, it is your day. Happy birthday to you.
Happy birthday. Very much, Shampo. Very much happy belated birthday. I'm glad that you had a wonderful, wonderful birthday and that the Seahawks won for you. You know, unfortunately, New England Patriots, I guess you just didn't quite make the cake. So that happens. Also, when you trolls showing up, get their weak, puny little butts kicked. Well, I hope that we don't have to boot anybody. I got a buddy of mine that's joined in the chat, and I want to just say that whenever they post something, before you just go assuming that they're one of these trolls, just know that I have a good friend out there. Expert, you never called me today, brother. You suck. You suck. Why didn't you call me? I love that, man. You know, Expert has an 8-hour stream coming up. Yes, he has an 8-hour stream coming up. He's going to be doing that on Wednesday. Why? Because he's a glutton for punishment, and we should punish him abruptly with that. So your birthday is in 1 week. Well, excellent, Peggy. That's great to hear. And Sean, happy birthday to you too, man. Yeah, Expert's good people. He did. You just weren't listening. Well, you know. The Expert. Oi, mate. Good to see you. Yes. Blossom, happy birthday to your husband. Congratulations, man. We'll hit all of those here really shortly. Just give me a little bit of a minute. Give me a little bit of a minute. I'm all in tears because, you know, the celebrations are happening. Well, not really. It is, he's not really shutting it down. This is just his report and recommendation. So he's basically saying throughout this thing that, you know, plaintiffs allege violations of the Lanham Act along with various state law claims currently before the court or motions dismissed by 8 defendants. And then he talks about defendant Preston filed a motion to dismiss, but because of a declared bankruptcy filing result in the case being stayed as the defendant Preston. So he can't rule on that. Doc 94, defendant Preston's motion to dismiss is not currently before the court. Also not before the court is the motion to dismiss recently filed by Paint Chips. The clerk of court entered a default against Paint Chips. The defendant Paint Chips has now appeared and moved to set aside the default and sought dismissal. Plaintiffs have just recently responded, and the court, the court, blah, 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 blah. Let's go down. I have to scroll down a little bit. The court will address defendant Paint Chips' motion at a later date after having had time to study the issues raised by the motion and the response. The information below comes from the factual allegations in plaintiff's second amended complaint. This stage, those allegations are accepted as true. Okay, that's all that is. So it'll be a little bit after that's taken care of. Background just basically talks about, you know, who Hales is. Defendants, various individuals scattered throughout the United States, claim to have joined together to form an anti-what the Hales media ecosystem. This ecosystem allegedly exists to harm plaintiff Hales' business. 2 of the defendants, Preston Cook, are near their vacation home in Florida. In this lawsuit, plaintiff Hales alleges that defendant Preston is liable for malicious prosecution and conspiracy 1 and 8, and that Cook is liable for conspiracy count 9. One of the other defendants, Deuce, is an attorney from Massachusetts who previously represented Preston and Cook in one of other federal lawsuits filed by Hales. Plaintiff Hales alleges Matskin is liable for tortious interference with business relationships, so conspiracy 5 and 7. Those are the counts. Helm, Hughes, Turkendirk, Lee, and Kesey, Raymond, and Luthmann are all people, most with their own YouTube channels, who Hales says have engaged in a civil conspiracy to harm his business. Documents 6, 10, 11, 12, 13, 14, and 15. Defendant Lee is also alleged to have violated Florida's Deceptive and Unfair Trade Practices Act, the Lanham Act, and to have tortiously interfered with business relationships in addition to civil conspiracy. Paint Chips is alleged to have violated Florida's sexual cyber harassment law, count 16. To help keep that all straight, here's a chart. So just so you guys understand, counts 1 and 8, counts 9, 2, 3, 4, and 6 for Lee, 5 and 7 for Deuce, 10 for Hughes, 11, 12, 13, 14, 15, and 16. In terms of relief, plaintiffs seek monetary damages against all defendants. Plaintiffs also seek injunctive relief. This is stuff that we already know. And the original complaint in this case was Doc 1. The claims in the original complaint were defamation, civil conspiracy, tortious interference, and aiding and abetting. Defendant Helm filed a motion for a more definitive statement, which led the court ordering Hales to file the amended complaint, Doc 16 and 17. Plaintiffs then filed the first amended complaint, Doc 35. They later filed a second amended complaint, which named current defendants, which just added Paint Chips and all that. Defendants and asserted claims involving civil conspiracy, tortious interference, all that stuff. It is the second amended complaint that defendants now seek to dismiss. In the pending motion to dismiss, defendants argue that dismissal is warranted under Rule 12b6 of Federal Rules of Civil Procedure for failure to state a claim on which relief can be granted. To survive this motion to dismiss for failure to state a claim, plaintiff's complaint must contain factual content that allows the court to draw the reasonable inference that the defendant is liable for the misconduct alleged. And now what they're saying is threadbare recitals of the elements of cause of action supported by mere conclusory statements do not suffice. So what the court is saying, that they need more definitive statements that they actually made, not just conclusionary statements that they, it can't be, well, I think they said this. So it has to be more specific. The kind of specific stuff that they've been doing lately, like, accusing Jeremy Hales of some pretty vile stuff. Those kinds of things right there can be brought in. But a court ruling on that motion to dismiss must accept the complaint's factual allegations as true, but legal conclusions are not entitled to presumption of truth. So it takes up Lee's motion to dismiss, blah, blah, blah. It basically just gives a breakdown of what it is. And it goes to sole permissible measure of actual damage is a difference. It's just more of court sightings. Looking at plaintiff's second amended complaint, it fails to plausibly allege actual damages caused by defendant Lee's violation of FDUTPA. Indeed, plaintiff's claims are ill-suited to requirements of the FDUTPA because this case does not involve a product or service, much less the delivery of that product or service in manner that was not contemplated under a contract. Now, that would be because of Popeyes, Louisiana, because they would be talking about, for example, if they were producing a widget. But you have to understand that the judge doesn't understand that the widget is their YouTube channel. That is, fucked up. Yes, no, this is what this right here is about, is saying that Boletho doesn't believe that YouTube is a product or service. It is a means for them to promote their channel. They should be able to cure that pretty straight up. Thus, the allegations in the second amended complaint provide no basis for determining that actual damages, as the phrase has been interpreted, for FDUTPA purposes were caused by Lee's alleged conduct. The second amended complaint simply states in conclusory fashion. So it has to be in very specific terminology. and especially lately, whenever they've been accusing Jeremy of a lot of things, they may be able to bring that in. I don't know, because I'm not a lawyer, so I could be wrong on that. Cause plaintiffs to suffer actual damages, but such allegations are insufficient to state a plausible claim. And that's what the judge is saying. They claim that there's a certain amount of damages for those violations, but the Second Amendment complaint fails to explain how that amount constituted the difference in market value of the product or service. So the judge is giving pretty clear information. Bolithos is saying you didn't give enough definitive information. That's what he's looking for. He's saying, give me more definitive information. Just the guesstimate isn't going to work for him. Similarly, the plaintiffs requested for injunctive relief under the should be dismissed. And the injunctive relief is not a standalone cause of action. That has to, and he gives the citations to what that law is. Here plaintiffs have failed to plausibly, well, according to him, plausibly allege what a consumer was actually aggrieved by deceptive or unfair practice committed by Lee. Those allegations in the Second Amendment complaint are about conduct by defendant. Lee was allegedly injurious to plaintiffs, not to consumers. And then it goes on about what those claims are, more letters and citations. Because plaintiffs have not plausibly alleged the FDUTPA claim, the claim for injunctive relief against defendant Lee should be dismissed. And then Lanham Act, it just basically tells you that they violated sections 32 and 43. It was intended to make actionable the deceptive and misleading use of marks and to protect persons engaged in commerce against unfair competition. And what they're talking about is like using trademarks. So and here's the thing that Randy could possibly do. He could drop things like the FDUTPA and the Lanham Act, and he could still pull in other things. But, I don't have any idea what he's going to do. Those seem to be the hardest struck throughout all of this. Is just saying that unless they were using his trademark and that kind of stuff, unless they could prove that there was those kinds of things being done, and then they could possibly do something. Looking to the allegations in the Second Amendment complaint, they failed to plausibly allege either element of claim under this citation here, and they have not plausibly alleged they have prior rights to any trademark registered or common law. So, which I think Hales does, and then they may have broken some of those, but they would have to prove that to the court. They also have not alleged facts sufficient to establish the second element of the claim. More specifically, the allegations in the Second Amendment complaint failed to allege that Lee adopted a mark or name that was the same or confusingly similar to plaintiff's mark, such that consumers were likely to confuse the two. And that's what they're talking about in this, and that's what the judge is looking at this on. This motion looks like suggestions, bringing up case files of what should have been done or could be done. No, that's pretty much right. That you have to understand that the judge does give them time to cure these things. This is something that judges will do, because there's a possibility the way that they're viewing it, they're looking at it as something that they don't want to have appealed. Judges hate having appeals come up. So he's saying, here's what the citation says. This is what you need to prove. And it is a guideline. The judge, because they can't not tell an attorney how to do their job, all they can do is pull up the case law, what the case law actually cites, and they can tell them to fix it. This is what Paint Chips ran into with Judge Henkel, is because what he submitted to the court in his filings was a worse shotgun pleading. What we're talking about over over 1,000 documents that were submitted that the judge was just like, this is a shotgun pleading, and I'm not going to even entertain this. I'm going to tell you why. And the judge wrote a 50-page document blasting him for his shotgun pleading. This is not a shotgun pleading because Randy's hitting all the points, but he's not making his point to the judge. It needs to be marked a little bit clearer for him. So he is giving a little bit of guidelines in this. And basically infer the defendant Lee has a mark, registered or otherwise, if there was such factual allegations. There's nothing in the second amended complaint that could lead the court to draw the reasonable inference that Lee employed marks that were similar enough to create a likelihood of confusion. The same is true with respect to plaintiff's claim the defendant Lee willfully violated Section 32. And gives more citations. To succeed on those claims, a plaintiff must demonstrate that its mark had priority. So he's basically just talking about like trademarks. Let's see. Turning to the allegations of the second amended complaint, they have not alleged they had registered trademark with the U.S. Patent and Trademark Office. So he's saying that those have to. That's what he's basing this off of. That is fatal to their claim that they violated Section 32. So if they don't have anything with a trademark company, then that's what he's basing it off of. So that could, plus Jeremy asked for jury. So Bolitho has no judgment saying it's just an official passing on the case where it's at. Yeah, pretty much. I mean, like I said, he has 14 days to file a response to this, and he can do that however attorneys do that. I would suspect that if he cleans up whatever he filed and makes very specific allegations in there, that could cure whatever the problem is, and Bolitho could easily rule on that and not make the recommendation to Henkel. Like I'll just use this as an example. Use this as an example. Say you're making a claim that somebody did X, Y, or Z, and you give like a broad spectrum of that. Oh, thank you very much for the gifted membership, Kathleen. Gifted a membership to Smitty, which received one. Thank you very much. That's awesome. Appreciate it. And I'll come back to these a little bit later on. So these certain spots that you have to hit, and if it's too broad, they want you to narrow it down, saying at such and such date they did X, Y, or Z as much as you possibly can, and this is how it affected me. You give them who, why, what, when, where, and how. Though you give them all that information. If you can narrow some of those, for example, they talked about how many pages there were of the YouTube links. If they could have narrowed that down and given the specific clips to all of that, saying here is where they did X, Y, or Z, then what would happen is it would go in front of Judge Bolitho. He would review the document that they said why this shouldn't be kicked to Judge Hinkle, and Judge Bolitho could look at it and say, oh, okay, that makes sense. Let's move on. Or you could say, it still doesn't meet the standard, and I'm going to forward on my recommendation to Judge Hinkle along with this extra piece of documentation. And then Judge Hinkle would read it over, or maybe Judge Hinkle reads it over and reads both of the pleadings and says, yeah, absolutely, we're going to dismiss with prejudice. Or he could say that we're going to keep the case going. And he could kick it back and say, nope, you're wrong, Judge Bolitho, and you need to hear this case. It needs to go on forward. So that's basically all that it is. So apparently Bolitho hates YouTube links. And I don't think that he hates YouTube links. What he says in that particular what he says here at the very beginning is that there's a voluminous amount of YouTube links. If they could have narrowed those YouTube links down to very specific things, that might have helped them out quite a bit. All right, smack that thumbs up. Yeah, make that thumb hurt. Moreover, it's not this court's role to rewrite a deficient complaint. And as you can see, moreover, it's not this court's role to rewrite a deficient complaint or to guess what about what claims a plaintiff actually represented one intended to bring. Thus, the court need not address whether plaintiffs have plausibly alleged a false advertising claim because the Second Amendment complaint does not actually assert such a claim. See this right here? He's given very specific directions. Clean your shit up. And that's what he's saying to Randy is clean your shit up. Just clean this up and we may move on. But he says instead it asserts that Lee violated 15 U.S.C., neither of which. Tammy B is in the chat. Tammy B, get to feeling better. And prayers are out to you. Thank you very much. Maybe not for letting me know. Prayers out to you and get to feeling better. I mean, it sucks whenever people go ill. It's no fun at all. And I feel for you. I really do. Man, I'm very doped up. Hey. So what are you doing later tonight, Tammy? Just kidding. I don't take advantage of women like that anymore. Nonetheless, to the extent plaintiffs intend to bring a claim of false advertising under the Lanham Act and that they have not cited, such a claim would be subject to dismissal. Is basically what he's saying. He's just saying here plaintiffs have not plausibly alleged that Lee used false and misleading advertisement that deceived or had the capacity to deceive customers. Now, unlike advertisements, the statement alleges made by defendant Lee on YouTube and other social media outlets do not propose a commercial transaction, except the money is involved there. Or any less. Okay. Speech is speech, which does do, what is that right there? Commercial speech is speech which does no more than propose a commercial transaction. Instead, the defendant Lee is alleged to have done would be better described as communicating information, expressing opinion, and reciting grievances, regarding plaintiffs. So that's all it is, just basically saying, that they suck. And, they're allowed to do that. That's what the judge is saying there. They're allowed to say, they're allowed to say that you suck. So you have to get more into specifics of the things that they were saying, and then they would be able to fix all of that issues. The fact that defendant Lee may have solicited donations or offered premium subscriptions on our YouTube page does not give rise to a cause of action for false advertising under the Lanham Act. Commercial advertising for the Lanham Act purposes, according to count 3 on the Second Amendment complaint should be dismissed. Now we get to the tortious interference. In count 4, plaintiffs allege defendant Lee tortiously interfered with business relationships. Now, under Florida law, the elements of tortious interference with business relationship are: 1, the existence of a business relationship that affords the plaintiff existing or prospective legal rights, the defendant's knowledge of the business relationship, and the defendant's intentional or unjustified interference with the relationship and damage to the plaintiff. And we're not going to go into reading the little sub parts. We can dig into a little bit deeper if it becomes necessary. Here is the Second Amendment complaint. The plaintiffs had a business relationship with YouTube and whatnot, as well as other companies' unspecified customers. There is no cause of action for tortious interference with a business relationship to the community at large. Additionally, a tortious interference claim requires the plaintiff to show a business relationship with identifiable customers. So if Jeremy can show that there were people that left because of her actions, and that's why, he reached out and said, hey, if you left because of X, Y, or Z, then it needs to be brought in, and we can prove that her behavior is causes. I think Ray would be a perfect example of that, if they would even mention Ray Bone Crusher in this, because his opinion, and he likes to say, oh, it was something else. Yeah. Right, Ray. That's insufficient to state a claim. The same is true with regard to the plaintiff's allegations involving their business relationships with other identified companies. Dismissing tortious interference claim because allegations that the defendant interfered with sales to various customers was too vague and abstract to satisfy the first element of tortious interference claim. So the judge is being very specific. He's saying it's too vague and abstract. Tighten it up. Give me proof. As for the allegations regarding YouTube and whatnot, plaintiffs have alleged existing a specific business relationship, so the first element of a tortious interference has been plausibly alleged. And the court will assume that plaintiff's general statement about defendant Lee's knowledge of those business relationships is sufficient to satisfy the second element. Okay, so he's saying part of it does. Finding that the defendant's knowledge of a business relationship need not be pleaded with specificity. So they're saying that's absolutely true. That leads to the third element, which is where plaintiffs have a problem because they've not plausibly alleged that Lee intentionally or unjustifiably interfered with their business relationship with YouTube and or whatnot, except we already have proof of them talking about though that kind of behavior of saying that they want to bring down Jeremy Hale's YouTube empire. That should be enough to satisfy that. And if Randy points that information out right there of them actually agreeing with that, that could cause the judge to say, yeah, absolutely, you have this right here. Although there are allegations that Lee posted content about plaintiffs on her own YouTube channel, plaintiffs have not plausibly alleged that Lee contacted YouTube or whatnot representatives or otherwise did anything to interfere with the business relationship. Well, actually, they do have that because on their own YouTube channel, and that would be for something that one of you guys out there that do all the nice little clipping where they were actually talking about going and striking any channel or especially Jeremy's channel for talking about specific things, and you put those in front of a judge and he's going to say, well, it looks like they're telling people to go out there and do a mass strike on people's channels. Just calling for it could be enough to do that. Affirming dismissal where there was no allegation that the defendant conveyed the information in question to the entity with which the plaintiff had business relationship, but they did. Nor there's an allegation that because of Lee's conduct, YouTube or whatnot terminate or otherwise altered their business relationship with the plaintiff. Yes, but it's to get them to stop doing it. So hopefully they can move this forward. But like I said, it's got to be one of those things that's proven if it's interfered with their YouTube channel. Thus, plaintiffs have failed plausibly allege the third element of a tortious interference with business relationship claim. They also failed to plausibly allege the last element, damages. Damages are an essential element of a tortious interference. Thus, dismissal is warranted if they fail to plausibly allege damage suffered as a result of the breach of the business. So you got to be a little more specific with what damage was caused, not just a blanket. We've got analytics. This means the plaintiff must connect the loss of a business relationship to the alleged tortious conduct of the defendant. They seek $1,835,000 in damages for defendant Lee's tortious interference, but the allegations in the second amended complaint failed to plausibly connect Lee's supposed tortious interference to the breach or loss of any business relationship, except for maybe, Ohhhh. Nor does the second amended complaint allege the value of any such business relationship that was lost or breached as a result of their conduct. Thus, plaintiffs have failed to allege fourth element of tortious interference because they have failed to allege the certain elements. And then we get to the civil conspiracy. Count 6, plaintiffs claim defendant Lee engaged in a civil conspiracy under Florida law. Elements of a civil conspiracy are an agreement between two or more parties to do an unlawful act or the doing of some overt act in pursuance of the conspiracy and damages to plaintiff as a result of the acts done under the conspiracy. The gravamen of a civil conspiracy claim of Florida is the underlying tort carried out by virtue of the conspiracy, not the conspiratorial agreement itself. According to the Second Amended Complaint, defendant Lee is alleged to have conspired with others to violate the FDUTPA, Lanham Act, tortiously interfere, as explained above. Those claims are subject to dismissal for failure to state a plausible claims become the underlying, and because the underlying claims fail, the civil conspiracy claim necessarily fails. So what the judge is saying is, because I don't find any of this right here, then there is no civil conspiracy, because you didn't have there was no violations of any of these, so the civil conspiracy just automatically fails, is what he's saying right there. And so he basically says that it should be dismissed. Defendant Ducey's motion to dismiss having resolved defendant Lee's motion to dismiss, the court will now turn to Ducey. And we'll go through all of the subtitle right there. He tortiously interfered with their business relationships and also participate in civil conspiracy. Tortious interference. The law regarding what is necessary to state a claim for tortious interference, as set forth above, will not be repeated here. The Second Amended Complaint alleges that he interfered with their contracts and advantageous business relationship with its customers and other companies, including Without Limitation, Whatnot, and YouTube. Except the only problem is in Ducey's case, they have documentation of him telling people that he wants to bring down Jeremy Hill's YouTube empire, and that should be enough to satisfy it. And if Randy can point that particular piece out and bring that up to him, that's going to be something pretty damn solid. What's that? Good. Let me ask you this. I see a bad thing for the defense, because with all this trying to sway converse to being brought to one court where Jeremy Hill requests a jury. I don't know. I don't know about that. Hey, Jen, how you doing? Hi, Jen. Okay. Defendant Matskin argues that plaintiff's allegations are insufficient to state a plausible tortious interference claim. The court agrees with Ducey. And it basically talks about the interference claim requires plaintiff to show a business relationship with identifiable customers, and that insufficient to state a claim. Basically, he brings the same thing forward. Tortiously interfered with the business relationship with its unspecified customers, unidentified companies. Regarding the allegations involving Whatnot and YouTube, they alleged existing specific business relationship. So if Whatnot, so here's the fucked up part about it. He's able to say all kinds of shit to Whatnot in a legal document, like into an email to Whatnot. I mean, think about this for a second. He's able to say some of the most horrendous shit about somebody to his contact. And if Jeremy would have actually lost the Whatnot contract, which helps keeps his business running, then he could sue him. Nice, huh? That leads to the third element, which again, plaintiffs have a problem because the Second Amended Complaint fails to plausibly allege that Ducey intentionally and unjustifiably interfered with his business relationships. Except that email, other allegations that he posted content about Hales on YouTube, plaintiffs have not plausibly alleged that he contacted YouTube representatives. Well, yeah. So here's what he's saying: have not plausibly alleged that he contacted YouTube representatives, except we have proof now that he has contacted YouTube representatives. All those emails that he was sending off to their legal teams is enough, I think, to satisfy that. Potted Plant is not reading all of Randy's papers. Well, and see, here's what you have to remember, Disabled Dahlia. Here's what you have to remember about that. And welcome. What you have to remember about that is whenever you're filing something of this caliber, you have to be very specific and you have to be very detailed in those. And that's what the judge has stated in this. He wants more specificity and he wants it to be rock solid. That's it. That's what he's wanting. But didn't Jeremy lose Whatnot? He actually had problems with Whatnot and almost lost it because of the behavior of these people. But he has to prove that. That's the thing. Yes, he did. It's in the exhibits. Well, and that's the thing, Wolfgang. He has to actually be very specific about it. And you can't just blend these things into a whole bunch of legal jargon. You have to be very specific with it. And this is the way that this judge is acting with this. I'm just reading the room here. What the judge is saying, I need you to be very specific with those court filings. I want them very specific. I want them pointed out. I don't want to have to sort through, 10 pages of email or YouTube links. I want you to point it out to me. He needs he doesn't want a magnifying glass. He wants it like slapping him right there. Yeah, Jeremy lost his membership. Exactly. Shizzy, have you noticed that 2 of Jeremy's lawyers have been punished, but none of Lynette's? Oh yeah, of course. Yeah, I've noticed that too. He's 2 quit, 1 died, 1 made her fire him. She's not better on better lawyer ground. No, I mean, Randy's doing a fine job, in my opinion, but I'm not an attorney. I don't have any way of judging that, if he's doing a good job or not. I would assume that he is. He's made it this far. There was no allegation in that defendant conveyed the information in question to the entity. As for Whatnot, they alleged that Ducey had contact with a Whatnot representative during email exchange regarding discovery. In one of their other cases that plaintiffs Hales has filed, but plaintiffs have failed to plausibly allege that this contact with Whatnot representative actually interfered with plaintiff's business relationship with Whatnot. See, they need more, like I said, right there. And the judge is being very specific about this. And I'm not trying to be an ass, but he's saying, be more specific, Randy. Like, you have to be specific if you want these to if you want them to pass muster, be more specifically. More specifically, as you can see, there are no allegations that Whatnot terminated its contract with plaintiffs, except there is in that filing. The business relationship with Whatnot is a result of Ducey's conduct. Of course, thus plaintiffs have failed to plausibly allege the 3rd element of tortious interference with business relationship. And the last element, damages, blah, blah, blah. And so they basically have to tie in those damages. You can't just throw a number out there. It actually has to tie into the actual damages. And that's what the judge is asking for. You can't just throw a number out there without giving me a breakdown of why it costs this much to deal with. Thus, plaintiffs have failed to plausibly allege the 4th element of tortious interference claim, civil conspiracy, count 7, that he's liable for civil conspiracy. That claim fails for the same reasons discussed above regarding plaintiff's civil conspiracy claim against Lee. Accordingly, count 7 should be dismissed. And Cook's motion, accordingly, count 9 should be dismissed. Everything above, Hughes, should be dismissed. Bone break, because of everything above civil conspiracy, should be dismissed. Kesey's motion. And the reason why, and see, this is where it's sort of, I get here. Let me explain just a little bit. The reason why you'll see so many of these go by really fast, and there's a reason for that, is because they were just named in the civil conspiracy portion of it. Because if they fail on the civil conspiracy and all the other stuff named above, then the whole thing fails. It's like a domino effect. Because if the judge is saying, listen, you're losing because of X, Y, and Z, okay? You haven't done this, you haven't done this, you haven't done this. what I'm going to do is I'm going to look at everybody that's named and where they're named at these. And if they're all correlated in there, if they lose at A, B, and C, and then D is the final outcome of yeah, you have no claim to it, he's just going to wipe all of them. So that's why you're seeing like all of these as a large group. Helm's motion. Now, this is where it becomes a little bit different, because with Helm had moved to dismiss for failure to state a claim, civil conspiracy claim. Aside from seeking dismissal, and this is important, Helm seeks to recover his attorney's fees under Florida's anti-SLAPP statute. Florida's anti-SLAPP statute prohibits a person from filing a cause of action against another person, entity without merit, and primarily because the person or entity has exercised the constitutional right of free speech in connection with public issue. It further provides that, well, and this is where they may run into a problem, because that was something that might bite him in the ass, because I think having that third party communication might cause a problem. Like that, I think that's one of the reasons why that was brought up against him for that. I mean, I don't know. That we'll have to see what the response is in there. Well, there will be 10 filings for sanctions tomorrow. Now, that would be stupid. That would be really stupid if they filed for sanctions tomorrow. Like, seriously, that'd be stupid, because the judge more than likely would deny that almost immediately, Randy. If they're doing, oh, I guess it'll be 8. Yeah, it would be really stupid, because at this point, there's another 12 days for them to respond to this ruling by the judge, this recommendation. They have 14 days to respond to the recommendation. Within that 14 days, I'm sure that Randy is going to file something. If he's any sort of attorney, that I'm pretty sure he is, he's going to file a response to this. And in his response, he's probably going to tighten a lot of things up. And we'll read that same document. And then I thought federal didn't have anti-SLAPP. No, anti-SLAPP is still there. But you have to understand what it is. You know, that's the trick right there. But it says that it further provides the court shall award prevailing party reasonable attorney's fees and costs incurred in connection with a claim that action was filed in violation of this. According to Helm, the anti-SLAPP statute entitles him to reasonable attorney's fees because plaintiff's allegations are without merit, and this lawsuit was commenced because Helm exercised his right to free speech by appearing on YouTube broadcasts to discuss Hales and other lawsuit plaintiffs Hales had filed. In response, Helm's motion to dismiss plaintiffs have argued that their claim against defendant Helm has merit, and Helm's speech was commercial speech that is not covered by anti-SLAPP statute. Helm has met the anti-SLAPP statute's first requirement because, as explained above, the claim against him lacks merit. Turning the anti-SLAPP statute's second requirement, the claim must have been brought primarily because Helm has exercised the constitutional right of free speech in connection with the public issue. The anti-SLAPP statute defines free speech in connection with public issues as any written oral statement that is protected under the applicable laws made before a governmental entity in it's interesting, entity in connection with issue under consideration or review by a governmental entity, or 2 is made in connection with a play, movie, television program, radio broadcast, audiovisual work, book, magazine, article, musical work, news report, or other similar work. Free speech made in connection with public issues is pertinent part merely requires a showing that the public speech is contained in or made in connection with one of the listed media formats or other similar modes for widely disseminating protected First Amendment speech. So this is the strike on First Amendment speech. And the judge believes that what Helm did was within his rights of First Amendment speech. And that's the way he views it. He says, you may not like what he said, but, you know, yeah, that's what he's telling you. It's First Amendment speech. The oral statements or were made as part of defendant Helm's operation of a YouTube channel, making law simple. And the written statements were made in connection with a YouTube broadcast that was being conducted by defendant Lee on her YouTube channel. These YouTube broadcasts or audiovisual works are similar works, and in the current world, YouTube is undoubtedly other similar mode for widely disseminating First Amendment speech. Thus, the requirements of Florida's anti-SLAPP statute have been met, according to the judge. In an attempt to avoid this conclusion, plaintiffs argue in cursory fashion the anti-SLAPP law does not apply because the lawsuit was aimed at defendant Helm's unlawful conduct, which includes but is not limited to actual commercial speech. Plaintiff's argument that the allegations against defendant Helm are based on conduct and not speech is incorrect. To this judge, the gravamen of the plaintiff's allegations against Helm are things he said and wrote, in other words, his speech, and that speech was not unprotected commercial speech. Or notion of commercial speech is speech which does no more than propose a commercial transaction. Even if commercial speech, that would not mean it was unprotected speech. Recognize the commercial speech, blah, 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 limited, then protected for non-commercial speech. Okay. Varieties of speech here. Defendant Helm's speech did not propose a commercial transaction. Rather, defendant Helm's speech consisted of commentary and criticism regarding plaintiff Hales. As such, it was written or oral statement that is protected under applicable law and within the definition of free speech in connection with the public issue. Because plaintiff's claim against Helm is without merit and was filed primarily because he exercised the constitutional right of free speech in connection with the public issue, plaintiff should be required to reimburse Helm for his reasonable attorney fees and costs in defending against this lawsuit under Florida's anti-SLAPP statute. MLS went to Ohhhh, took pictures of Hale's headquarters. I heard somewhere, yes, he actually streamed it, if I believe, but that still doesn't rise to any level of it. You have to understand that, you know, doing bad things, you can still do bad things and be protected under First Amendment. You might run into an issue because of reaching out to a certain person, actually reaching out to them, and that might end up causing some problems in Ohio. I don't know. I mean, it just depends. Plotted plant made brandy pay. So let's drop the cases in Jeremy. Drop the cases in Jeremy. I have to pay them for the lawyers. They don't have any lawyers. I mean, that's the thing. You know, if he does lose against Helm, he'll have to pay Helm for his attorney. He'll have to pay Ducey for his attorney, but the rest of them that are pro se, no, they don't have any attorneys. And if they hire attorneys just to come in to fight this, then more than likely, you know, if Jeremy says no, we'll let it go, then he would get off pretty damn easy, except for maybe with Ducey and Helm, but that would be completely different. Never watched their garbage streams. Well, that's up to you. That's up to you. I mean, you have to understand that I've had Dave Helm on my channel. I've been on his before. I don't have any beef with Dave Helm. He does his own thing. He's actually, you know, in my opinion, he's a pretty good attorney. I think the way that he approached the situation was pretty shitty, but that's just my opinion. Accident, my ass. Well, hey, no, there was no accident. It was not an accident. Defendant Teschendorf's motion to dismiss, and he basically says the same thing about this. For lack of personal jurisdiction, brought dismissal. For failure to state a claim, court will first address the jurisdictional argument that moved to the failure. It says personal jurisdiction may exercise personal jurisdiction over a non-resident defendant to the same extent that a Florida court may, so long as the exercise is consistent with federal due. And this has to do with the service portion of it. jurisdiction exists. Plaintiffs allege that he operated a YouTube channel, made comments, blah, blah, blah. Sufficient for personal jurisdiction under Florida's long-arm statute, which the judge agrees that he should be part of this. Finding that Florida's long-arm statute reached out of state website conduct because the website wholly engaged injury in Florida. Having found that Florida's long-arm statute, now see, this works in a good way. I have no idea who Helm is, which is fine. I mean, he does YouTube. He does a lot of the law tube stuff. He's been around for quite some time. I think he's probably been doing this a little bit more. Yeah, it's Randy's turn to bat. It's too bad that David Helm did go find his property. Are you right? He does have, yeah. It is, like I said, it's unfortunate that some of the stuff that Helm did is not the behavior that I would recommend doing, because, you know, bad things can happen acting a fool like that. But like I said, it doesn't stop it from being to do it. YouTube channel got banned, yet they think they are in the right. Well, I think there was a strike on his YouTube channel, and it might have been a strike 3, something like that. And well, he was retired from YouTube anyway, which, you know, was weird in the first place. He said he was retired from YouTube and then came back and started in with Hale's stuff, just doing his thing. So, and that's what got other people upset. I mean, you can still have your YouTube channel struck for other things. It doesn't take, completely misbehaving. If there's mass flagging going out there, which I've seen happen, just because your YouTube channel gets banned does not mean that you're wrong. It just means that you didn't follow YouTube's terms of service. Two different things, Smitty. It is two different things. So if you don't follow YouTube's terms of service, here's a perfect example. On YouTube, I can read court documents all day. Doesn't break terms of service. If I show someone's address, although it's a publicly available court document, YouTube will tell me to remove that. And they'll actually put a thing on there, and they'll block my channel. They'll say, nope, you showed somebody's address, and we're going to basically pull that down until you remove that portion of it. That's just YouTube's terms of service, which are a little more strict than, your constitutional rights, your First Amendment rights, freedom of speech, sunshine laws, whatever you want to throw at it. Their terms of service are very specific. But you're on YouTube's platform, so you have to follow their rules. It's the same way. It's not illegal to carry a firearm in the state of South Carolina, for example. It's not illegal to have a concealed carry. But there's places he wasn't allowed to use YouTube on his channel. Oh, what the hell's on his channel? Yeah, he was told no. And he was removed from that. And he did anyway, and that's what might have gotten him in trouble. Get 3 strikes and you're out. See, you have to ask for permission from certain people if you want to show their stuff on YouTube. I don't think Helm was or is acting in an honorable way. Well, and absolutely, that could be absolutely it. Since he was a lawyer, he should know better. I absolutely agree. And I've said that before. I think it was unfortunate the way that he behaved, but that is still his ability and his it doesn't necessarily fall into a legal realm there. I mean, you can argue it both ways and lose both ways. It just depends on who you get in front of. Somebody reported Tug's channel. I was watching his video and it disappeared. Yeah, that happens. They do mass flaggings on people. Hopefully it wasn't tonight. Hopefully he didn't lose it tonight. Now if it happened tonight, then it'll be back up. He's just making a correction in it. looks like he marked it private, doesn't mean reported. Oh yeah, see that's completely different. If he marked something private, then it's not. Yeah, Tug got sick tonight. Yeah, that's what I heard. He's not feeling well, but you know, prayers out to Tug. He'll be doing good. He'll be fine. New meds messed with him. Yeah, and he might have said something that he didn't mean to say. You know, that happens. You know, and he may be just going in and go, oh, I need to fix that, and because he's not feeling well tonight, just made it private until he can go back and fix it. New meds mess with him. Yeah, prayers for Tug, most definitely. We want Tug feeling, you know, good, up to date. That's how we like having Tug, because he's fun. Constitution permits the exercise of jurisdiction. Basically the Constitution litmus test for personal jurisdiction, and they're going to go into all of this. Here, the court finds that plaintiffs have well, in this you have to understand that this works good for Dave and it works bad for Dave. One, and I'll give a brief breakdown of this. This is where I wanted to go with this. In this right there is it works good for Dave in the fact that, you know, he's in this portion of it. The judge is saying, I agree, Dave, you're free to go. But on the other hand, he's also saying that stupid Dave was properly served. So if this case continues on, if Randy wins his motion, and even if he doesn't win his motion and he has to go to appeal, it's going to verify that stupid Dave was properly served, according to this judge. They have alleged that his blah, 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 goes through all that. He should have anticipated that any harm caused to plaintiffs would be suffered in Florida. Accordingly, stupid Dave had sufficient minimum contacts with the forum state to satisfy due process. Finally, the court must consider whether exercise of personal jurisdiction would comport with fair play and substantial justice. Relevant factors include the burden on the defendant, the forum's interest in adjudicating the dispute, the plaintiff's interest in obtaining convenient and effective relief, and the judicial system's interest in resolving the dispute. Has not offered any evidence of his finances or any other limitations on him to show that he would be burdened by having to litigate the case in Florida. You hear that right there? Do you understand what that says right there, stupid Dave? It says, you have not offered any evidence of his finances or any other limitations on him to show that he would be burdened by having to litigate this case in Florida. Moreover, the allegations of this case are highly Florida-centric, which provides Florida with a strong interest in hearing the case, and they have an interest in this case resolved in Florida. The court therefore finds that exercising personal jurisdiction over Teschendorf would comport with fair play and substantial justice. But then you get down to the claim, and it says the claim in count 13 should be dismissed. Conclusion: for the above reasons, it is respectfully recommended that Helms' motion dismissed, granted with claims against defendant Helms, dismissed with prejudice for failure to state a claim. Turkendorf seeks reasonable attorney fees under his anti-SLAPP statute, but defendant Turkendorf is not entitled to such fees because he is proceeding pro se. Stating that the defendant as a pro se litigant was not entitled to attorney fees under anti-SLAPP statute, there's no basis for providing plaintiffs with another opportunity to amend. Plaintiffs were previously given the opportunity to amend after Helm filed a motion for a more definitive statement. Plaintiffs are represented by counsel. 11th Circuit has never required district courts to counsel plaintiffs more than one opportunity to amend a deficient complaint. So they're saying they're not giving him any opportunity to amend, but if he cleans up his pleading and why this should continue, he might be able to get it passed. Hughes' motion to dismiss be granted, dismissed with prejudice. Matskin's dismissed with prejudice. Cook's dismissed with prejudice. and Lee dismissed with prejudice, and Bone Breaks dismissed with prejudice. Granted, Kesey's dismissed with prejudice for failure to state a claim. Granted, the claims against Turk and Dirk dismissed with prejudice for stated claim. This matter be recommitted to the undersigned for further proceedings involving defendants Preston and Paintchip, as well as the determination of the reasonable attorney fees due to defendant Helm under Florida's anti-SLAPP statute. So, if you see right here, okay, this is very important to read. So while these fools are out there celebrating, thinking that they are going to be able to come back and attorney's fees, as you can see right here, the determination, according to this judge, would only be for defendant Helm. Okay. So if Jeremy stopped right here and said, I'm not going to pursue it, I don't know Jeremy's mind. I would assume that he's probably going to try to get this in front of the judge. What this right here is telling, if the judge adopts this, if Randy's pleading fails and the judge adopts this, the only person that would get any reasonable attorney fees is David Helm. You understand? Okay. It's not like they can come back and say, oh, we need to get paid for this. Most likely the judge would tell them no. But they should hire attorneys to have them tell what was the best idea to do. I mean, that could be the smart thing to do. Is get an attorney and have them tell you which way to proceed. But because they're all pro se, the only person for determination of reasonable attorney's fees due to David Helm. That would be something that's something, but amendments. This only sorry, I don't understand, Missy. But recommendations. This is only. Oh yeah. Oh, sorry. Yeah, your part got cut off there. It says, but recommendations. This is only recommendations. Yes, this is only recommendations. The judge could adopt something different. It happens. Hey, it's the dyslexia. I have a hard time even spelling dyslexia. But yes, that is the most important part, which is the very top thing. This right here. This little piece right here is a report and recommendation. If the judge adopts his report and recommendation in whole, if Randy comes back and files something, judge uses this recommendation, he could easily say, I'm taking the recommendation, and the only person that's going to have to pay is Jeremy out to David Helm for reasonable attorney's fees. That's it. They won't be able to get any extra money off of this, as far as I know. I could be wrong. I'm not an attorney. I'm just an idiot on YouTube. But you know, that's how the judge is going to look at this as a recommendation. Hey, I'm not above apologizing when wrong. No, I'm definitely not above it. But the good part is getting into bankruptcy stuff. But I think we need a song before we do that. We need to really show. We really need to show how wrong some people are some days, because it's so much fun.
Yeah. Come on. Fleahead. Grab a chair, fat ass, you're gonna need it. Let's run your sticky note opera. You start with like that's your whole case file. Blew your feelings to it, call it evidence for a while. Don't fall for lies, finger wagging at the moon while your ass that screams. Please believe me, I'm the go where the hell you going. If he had proof, he wouldn't ask. That's comedian gold. Cause receipts don't just appear cause you said something. Yo, shit's getting old. You don't agree reality with caps lock decrees and act shocked when we go cool. Show me, please. Oh, you mad? Sure. Talk too much, you lose. Bluffing hard, you lose. Trust Louis, you lose. That grand, you lose. You lose. You lose. You lose. You lose. You lose. I'm a creditor, congrats, just a fat ass in the room. Still talk like always gossip, got a tick, tick and boom. Potential contingent, tossing herbs like shields. Think the court gon' faint cause you spoke in the field. You got my licks already, so which is to stop the click. Can't cry interference while screaming, check my heart rate quick. That ain't threat, this meltdown with customer service vibes. Yeah, keep going. Play both sides. You lose. Story slipping. You lose. Posture didn't plead. You lose. Volume don't make it true. Intuition, you solo psychic show, grilling yourself. Still don't know what you know. Did you do X? No. Why? No. It's Tyler Alibi in the cookie jar, bro. Yelling, it doesn't exist. Loud as hell, think volume makes truth disappear. Now your lives rings fast. Real shit stands quiet. Yours needs vetting, dumbass. That's cute. Swear you clean. You lose. Prints everywhere. You lose. I didn't fool, I heard. You lose. Facts, just stories sold. You lose. Baltimore, help the family, spoke true. Say the kid, turn through D's in the blockbuster, where you to lead. You say you used it for content, you doing the same dance. Posting updates, name drops, chasing likes in advance. Success with me like flexing wounded one. But you wrote a trilogy about them called Enjoy Your Day, son. Yeah, that's the tale. Real talk, walrus, receipts don't need theater. You got docs and vids, like them let them speak clearer. Trust me, jackass, like a legal move anywhere. Except fucktard college, you headlining there. You feel that? Talk too much, you lose. You lose. Bluff and clutch, you lose. You lose. Swing for cool, you lose. You lose. Script reading full, you lose. You lose. You lose. Every time, you lose. Every time. You lose. Not scared at all. Scared folks always say that first. Don't think of live like middle school reverse. You sell courage, we see sweat and giggle after jabs. Keep poking fortune, puking law, announcing what ain't there. Harder you perform, clearer you trying to convince yourself. Not us. You lose. Yeah. Enjoy your day, y'all. Fat ass. Keep laughing. Makes your collapse sound like applause.
Yes. This is how can pot plant recommend anything without evidence? Well, and you have to understand that the way that the judge is viewing this, and we're going to remove that right there. The way that the judge views this is Randy didn't provide enough evidence to satisfy the claims that he was making. That's what the judge is claiming. So it is for Jeremy, for Randy, for Hales to prove that there's enough evidence, and the evidence they provided, according to the judge, is not enough to satisfy these claims. So that's why he can make a recommendation for this, if that's why you're wondering. And his video was taken down. Huh. Well, and I don't know that it was taken down. I hope not. Remember your message about directing when trying to be sure your chat message gets to the right person. I hope so. Yeah. Yes. I understand what pot plant is claiming. Yeah. I mean, it sucks, but you know, that's where we're at in this situation. So that's how you have to view the documents of what the judge is believing. I hope not. That would really suck for him. There's probably something else going on. Who knows? Happy birthday. Happy birthday. Well, let's give a little bit of birthday there, and just for your birthday.
Oh my, happy birthday to you. Happy birthday to you. Happy birthday, it is your birthday. Happy birthday to you.
Well, let's see. What you said was on Facebook that Tug posted something about his channel being struck. Let's look and see what that is all about. That's never good. If Tug is getting struck down, what exactly caused it? Apologies, Star New Med. Didn't expect my BP to. Oh, okay. So what Tug says, let's see what Tug is saying. He had some super chats, etc., but didn't have a chance. Next time his blood pressure shot through the roof. Fed 2 case has been recommended to be dismissed. Inhales for his bottom post. Some are confused. So note the work recommended. Yes, that's absolutely right. Let's see what happened here. So what's going on? 1 hour ago, he just said that his blood pressure shot through the roof. He doesn't have anything about his channel being down in there. It just looks normal. Let's see what's going on. Let's see what's up with his stream. I'm looking really quick just to see what's going on with the Tug, because hopefully he did not get any problems. Let me see. That's fine. Yeah, there's so many people that I'm looking at. Let's see what's going on. All right. Let's see what's up with his. No, it still looks like it's up for me. No, that's yesterday's. Well, let's just go look at history here, and that'll give me a better idea. It's not showing. Yeah, I'm not seeing that it's up, so it's not struck. Tug took it down. Yeah, there's a reason why he took it down. Oh, he has a post on his YouTube. Okay, well, that makes more sense. Let's look and see what his post is. Hey, folks, I removed tonight's stream because it ended abruptly. Okay. Yeah, so yeah, there you go. That's yeah, it makes sense. He says 19 minutes ago, he says, "Hey folks, I removed tonight's stream because it ended abruptly. I'd taken new medication. My blood pressure spiked. Made me feel quite ill. Apologize. We will cover everything skipped or missed in a proper stream. Thanks." See? Not a short, just a statement. Yeah. Gotcha. Yeah, 15 minutes ago. Here, I can bring that up. That's not very hard. Give me a second here. And I'll just share it with you. Let's stop that right there and share screen. So it's pretty straightforward what he says. What I can show you here is Tug says that hey folks, I removed tonight's stream because I ended it abruptly. I'd taken new medication, my blood pressure spiked, made me feel quite ill. Apologies. We will cover everything skipped or missed in a proper stream. Thanks. So he wasn't struck. He just pulled it down. He's just not feeling up to par tonight. So we will hope that he's able to, get feeling much better, because we don't need an ill Tug. Now, please, we'll celebrate that also. That'd be sort of sick. That'd be sort of sick, don't you think? All right, let's get into this bad boy. Yeah, we'll bring that up and give you more of a bigger screen there. Let's see what exactly this is all about.
A federal judge ripped into saran wrap in bankruptcy court as he asked for us to pay Lynette. You think that was gonna happen, George?
For damages? What damages? If anything, she's caused us damages.
Ooh, buddy.
Another huge win for team. What the hells in bankruptcy court
Well, I
today.
kind of saw that coming, though.
Oh, you must have that Arabic intuition.
I do. I'm very intuitive at times. Although I do have my times where I'm not intuitive at all.
Well, these things happen. Well, we were scheduled for bankruptcy court today. Two things were going to be heard. Number one, we filed a motion against them stating that they were exempted under homesteading. Now, homesteading may mean a lot of different things to a lot of different people, right?
Correct.
But basically, in a nutshell, in the state of Florida, and it's not like this in all states, homesteading, basically you say, this is my piece of property, I get a lower tax rate because this is where I reside. Now, here's the funny part, okay? Because Lynette and Crook live in Otter Creek, stalked us to Otter Creek.
Yes.
This tiny little town that is incorporated.
Correct.
Because they live in a town of Otter Creek that's incorporated, where they followed us and stalked us, homestead exemption will only apply to half an acre. That's it.
That's true. I mean, and I don't know how it is in other places. But yeah, that's the way that it, from what I understand, it's the way it is in Florida. It only applies to half an acre, but he gets into this a little bit more.
Because they're in an incorporated Otter Creek. Now, this is the funniest part.
Okay. Let's do the math.
Okay, let's do the math.
Half an acre.
Half an acre out of 1.66 acres that they purchased across the street from us. So 1.16 acres is 100% going up for auction in the federal bankruptcy court. Now, only half an acre would actually be able to be exempt from that full auction, as they claim Florida homestead.
Correct.
Major problem here for them is they live in the Otter Creek that's incorporated, which constrains it to half acre. You remember when we were like,
well, it has to be more, well, and it does constrain to a half acre, but it also has to be, they have to have a home there. It has to be a livable structure. If I read the documentation correctly, that the documentation shows that there has to be a livable structure on that. And like a motorhome is not considered that. A shed is not considered that. There has to be, there's certain elements that have to meet for a livable structure. There has to be hot and cold running water. It has to be its own private bathroom. And the reason why they did this kind of thing is they wanted to make sure that people didn't just move onto the property, pitch a tent and say, I'm homesteaded. It's just, it doesn't work that way. When is that? They had the whole, when it started, paint chips, lips, stupid Dave, Rayleigh's, they were also giddy. The very little bit, but I heard it anyway. Yeah, I saw a little bit of it and I'm just like, yeah, less than a third of the property. I mean, but there also has to be a livable structure on that property for it to be homesteaded. Like an actual livable structure, not a mobile home. A mobile home is not considered a livable structure.
Just unincorporate Otter Creek.
Yes, and she was against it.
She's like, no!
We don't want the county to take over. No!
Isn't it ironic? If Otter Creek would have unincorporated,
Oh, excellent.
she could have homesteaded all of it.
do what you need to do.
1.66 acres. Now, you heard us stop talking about unincorporating Otter Creek once this all came up because we already knew where we were headed. So, the funniest part is if she would have pushed to unincorporate Otter Creek, she potentially could have homesteaded it all. But now she's guaranteed to lose 1.16 acres. And she's trying to fight for half an acre, saying that she's exempt under the Homestead Act. But we filed to say, no, we're objecting to it. She's not homesteaded. She does not have a valid.
And that was one of the filings that we went over in the bankruptcy. That was what his attorney filed in this was, this is why it can't be homesteaded. There's certain elements it has to meet. And that property did not meet those standards whatsoever. So it wouldn't give their stream any modicum or effort. No, I have no idea what they're. All I know is that they were jumping up and down and so excited about it. But hey, it's it's like I said, it's like popping a cork at halftime, celebrating a win when the game isn't over. So they can do however they like to do and celebrate away. Just know that it's not over. There's still another 14 days. Colleen make a 62040 6240 says gifted 5 memberships, and it is that time. You know what time it is. It is time for that.
Welcome to the shit show.
Oh yes,
Every single day.
it is
A new flavor of fuckery.
because everybody sucks, you see. Thank you so much, Jesse Turner, Missy Sparkles, Chris Clevens, Malin. If you got one also, welcome, Malin. Awesome, and Double Karma. Thank all you new members. Thank Colleen. Thank you very much, Colleen. That is very kind of you. We appreciate it. And you are all welcome. Oh, thank you. No, I do thank you. Hey, Malinin. Good to see you. Yeah, she was hanging out with MG last night. Yeah, it's so much fun. I could only hang out for about an hour over there. I was like, ooh, I've got to get some sleep. So
building permit. Oh, wait.
Nope.
Why doesn't she have a valid building permit? Oh, fleece on the fraud. That fraud raisers that she had and then didn't give her the money.
I do need to put my 2 cents in on this.
Okay. I'll take 5. You got a nickel?
Sure.
Yeah.
Wolfgang. Yes, everyone was with prejudice. David Helm is the only one that filed for the anti-slap, and may be able to recoup attorney's fees on that. That's the way I read the judge's recommendation.
I'll get it to you later.
All right.
I owe you. It's no one's responsibility but Lynette, the property owners, which is Lynette and John Crookie, to pay their bills and have the funds to build whatever it is that they wanted to build.
Agreed.
I'm not defending Fleesa, but it's not Fleesa's problem or responsibility to make sure that they had everything, their ducks in a row in order to proceed to build.
Fleesa has way bigger problems.
True.
I mean, we're talking felony convictions, fraudulent fraud raising. Her responsibilities are criminal level, and so
Yes.
she's got her own issues.
So Felisa, on the other hand, with what she did and raising funds under other people's names, whether the donor intended to send it to whoever other than her, should be held accountable for doing what she's doing.
The bankruptcy lawyers that are working for the trustee are going 100% full in on Felisa. They are starting with her deposition first, subpoena first. She's target number one.
Yes.
And then flowing down into Lynette and Crook. Well, Deuce will be a part of all of that as well.
Yes.
So they know that's their goal number one.
She'll be the first one to be deposed.
Yep.
Yeah, so there's celebration over this right here. It might be short-lived. It might be short-lived, their little celebration and jumping up and down for joy. There's a possibility that whenever the attorneys for the trustee come in and step in and actually start digging into, wait a second, this money was raised on behalf of Lynette and doing a project. Doesn't matter how it came in. The judge can easily look at this and go, yeah, you need to show every single bit of it. And of course, they'll subpoena Felisa. And whenever they do, she'll be brought in. They'll have very pointed and specific questions for her. And if she doesn't do what she's supposed to, she could run into a lot of big problems. And that is not something I think that she is looking forward to. She should probably be sweating just a little bit, because that the level of craziness that she's running into is going to be massive. I mean, it is a big thing. Debbie Baker, thank you so much for the 10 gifted memberships. What's on Fed 2 that came out today? We'll just do a rewind and you'll see exactly what came out today. And I'll get to you here in a second, Debbie Baker. I just wanted to address this really quick. What happened today in Fed 2 was there is a proposal to the district judge, which is Judge Hinkle. There's a proposal. Now they have Jeremy and the Hales emblem have 14 days to file an objection to it, or, make cure whatever it is that the judge is asking for. So they have 14 days to respond. If they don't take those 14 days to respond, it'll go in front of Judge Hinkle, and 9 times out of 10, the district judge will take the recommendation of whatever the magistrate judge proposed. Now, if they do take that opportunity, which I would assume that he would, they'll file something, and then that'll go in front of Judge Hinkle, and he'll probably review both of them. Or it might be that the magistrate looks at it and says, oh yeah, this answers all the questions that I had in there. And then he can remove that reversal, or reverse it himself or whatever. Yeah. And Susan got one. Oh, one of my favorites right there. The beautiful Lethal Lauren. She's got her own YouTube channel. She's awesome. She's been covering Justin Baldino, Laura Owens. I mean, she's doing a lot. She's doing a lot. Paul Harding received a gifted membership. Storm Rain also received one. R. Ford got one, also a gifted membership. And then Carmen, not Electra. I don't know. Carmen, not Electra might just be better. Job Amazing Ditsy, Doris, and I love that name, Ditsy, Doris, and that's a cute puppy right there. J. Nell also got a gifted membership, and Lisa Aaron got one also, and this is for you.
Welcome to the shit show. Every single day, a new flavor of fuckery. Cause everybody's such, you see, and they're dumber than a bag of clots. Monday,
Yes, now.
Tuesday,
Oh, yeah.
Wednesday.
Oh, we
And
go.
then 4 more days of increasingly stupid, ridiculous,
Ignorant, balderdash, poppycock, bollocks, and fuckery. Yes. I want to wish you all a good night. Will you sleep well, Shirley Martin? And don't you worry. And finished watching the stream when I get up. I've been up for 3 days, no sleep. Nighty night. You sleep well, Shirley. You sleep well. And we'll look forward to seeing you there. And also, you got a well wish there from Brenda that says, well wishes to you, praying you are well, Miss Debbie. Yeah, she's been just trying to get a little bit of rest. Yes, let's continue on with this right here. This is crazy.
Before the debtor. Isn't that interesting?
Isn't that interesting? Huh? Yeah. Oh. Yep.
Okay.
Hell, all right. So let's get back into bankruptcy court.
Oh, I have one more thing to ask.
Oh, okay.
So that half acre that can be exempt in Levy County
Yeah.
that was incorporated.
Yeah.
Does that belong to the Turtles?
Oh,
And Debbie Baker says, hi, chat mods. I've been sitting back listening. I hope you all have a wonderful evening. Turn off chat. So have a wonderful evening and a fantastic tomorrow. And we allow Debbie to type in all caps because she has a hard time seeing it. So we allow her to type in all caps. So don't you dare harass Debbie Baker. I will put a hurting on you. Didn't Helms use an insurance policy for his lawyer? If so, any money be paid to the insurance company? Yes. Yeah. If he wins this, if Helms wins in this motion, then yes, his insurance company would receive it and it would take care of the attorney's fees. Basically, it wouldn't cost him anything. That's usually how it works.
Is it the other part?
I thought it was the beautiful property, leaving a legacy for my beautiful. Who knows? By the way, I think the half acre that's going to that would be homesteaded would be the north side, which has the pile of poop, pile of garbage, pile. Wait, hold a second. That's the south side.
When you say
isn't
poop,
that the east and the west side too? Wait.
When you say poop,
goodness.
can you specify? Is it the poop that Lynette called 911 for because she found poop in the steak holes, that side, or the other side?
Well, I can assure you, it will not be the shell thing that she calls.
Thank you, Colleen.
Yeah.
Okay.
And thank you again, Colleen, for the gifted memberships. That was very kind of you. Heather can't help but want to see her fall from grace. Well, and I don't wish anybody to suffer. That's the thing. I don't want to see anybody suffer. That's just not in me. I just hope that she finds her way. That's about all I can do.
It's that barnuminium is basically an impractical shell of a structure. It's a shell. It's a structure where she can store more garbage.
All right. So George and I know we have a meeting here in bankruptcy court. Now, obviously, I'm having pre-conversations with my lawyers. I have a specialty bankruptcy lawyer working on this as well, alongside with Randy. And we are all working with the trustee and with the trustees' lawyers as well to make sure that
that's why I enjoy George so much. Is she's got those little slaps in there. They're just hilarious. Hurricane says, did I miss all the cope? Jeremy is lawyer completely lost. I can't wait to hear how the courts are corrupt when the judge ratifies the filing. Well, no, that's not how it works. See, you have to understand is they haven't lost anything yet. Hurricane Von Hurricane. It's thank you very much for the $5 super chat, but that's not how it works. So you have to understand that it was only a recommendation from the judge. So whenever you understand, if you understand how this works, there's a recommendation that Judge Bolitho made. There's a response that can be filed within 14 days that might cure those deficiencies. So there's not a loss right now. All it is a recommendation to the district judge from the magistrate judge saying, hey, this is how I think that you should rule. If there's no response, then there is a possibility that Jeremy would lose that portion of it. And as far as what he would lose, it's not really a big loss. All he would be doing is paying Helms's attorney's fees. The rest of the people would be just sort of kicked off to the side, and they could easily file this in state court. If they took it out of federal court, they could come back and file it in state court. There's multiple different venues for doing that, but thank you very much for the $5 super chat. No, he totally belongs here, Debbie Webb. He's absolutely fine. No, he has every ability to come in here and throw in a $5 super chat and get schooled a little bit. We enjoy, people coming in here and, getting all excited because, they're out there popping corks at halftime right now. Even if they're not rooted in fact, maybe they'll learn something or get a new perspective. No. Well, and I think someone posted something on one of my streams. It was an earlier stream. Look, Jeremy lost. Your daddy lost. It was like, well, I'm not beholden to Jeremy. I never have been. It's good for their coat. He's going to lose. Well, that's a possibility. There's always that possibility. There's nothing said anything, but it's good for their coat. He's going to lose. Okay. Thank you, Hurricane Von Hurricane. Glad to see that. I'm glad that you feel nice and special, but that's okay. You'll maybe learn something at some point in time. But till then, you can just chill out.
Everything is recovered and all creditors are paid appropriately. That's a huge thing. So the very first thing I tell my lawyers is if Lisa shows up, number one, we want her on camera because this is being recorded by the federal court and we want it. We want to see the no teeth.
Well, and it's proper court procedure for for the person to turn the camera on, identify themselves.
It's legal. Have to.
So it would have been a requirement.
I've never said anything of the sort, but you can keep on wishing and hoping, Hurricane Von Hurricane, but you can just chill out and calm down. You'll be just fine. One of these days, you'll maybe understand what court filings are and actually read them sometime. Or you could just rewind and go back and watch from the beginning where I actually give a good breakdown of it, and you'll be happy. You'll be happy if you actually learn something. It would be amazing for you, wouldn't it? That's okay.
For her to attend.
And if you want to continue on and keep being difficult, your protector will do jail time. Yeah, and Hurricane is fine. They're excited because they feel emboldened. Yeah, leave the trolls alone. We'll go troll hunting. Only maybe he's on top of it if she needs to. If he continues to misbehave or try to, think that he's got something over on me because my channel is Shizzywhiznut. It's not What the Hales. And two, I'm not beholden to Jeremy Hales. I'm very grateful that I've got some of his audience, but this is my channel and I do what I like. Isn't it beautiful? Maybe you could do the same. If you were smart enough, Hurricane, if you actually had any what do they call that? Testicular fortitude, you could start your own YouTube channel. It would be amazing. If you started your own YouTube channel and told us everything that you believed, that would be so wonderful. people would be so excited. It's amazing that you have to come over here and think that you're something special. But hey, you are something special. And oh, wait, that's right. I don't have the special helmet anymore for you. Or I'd be happy to, lend it to you so you could, beat your head against the wall a few more times and show us how smart you really are.
I was so looking forward to it, but alas, Fleesa did not show. I don't get it. How did a potential creditor more than Jeremy Germ not show up to a bankruptcy hearing?
Oh, that's right.
Yeah.
She wants to be a creditor.
Maybe she wasn't privy to that information.
Maybe not. Okay, so she doesn't even show up.
No.
As a matter of fact, neither does Lynette. So we log in to the Zoom meeting. We are allowed to be in federal bankruptcy, the courtroom through Zoom. So we log in at 7:15. And
7:15.
Excuse me, 10:15.
Okay.
10. Okay.
Jeremy has his
All right.
dyslexic moments.
You trying to say dyslexic was dyslexic. At 10:17, we log in. All right, 10:17, we log in. We're in the waiting room. The judge, which I thought was the judge, but it isn't. It's actually the deputy in the courtroom, lets everybody in at 10:25. Mm-hmm. And immediately you see it's being recorded. It's being recorded. And we were hoping for that. We were going to go ahead and FOIA over that. And so that's good. Now, at 10:25, I noticed something. I noticed there's no saran wrap. I see a ton of people. Oh, no
yeah.
saran wrap. No Lynette.
Nope.
No Fleesa.
No.
Where's Deuce? Is he out on the loose in Armenia? They're not there. 10:26.
Oh, it's beautiful.
Saran wrap does show up.
Mm-hmm. Now, the meeting was scheduled for 10:30.
Yeah. 10:28, Travis, what you doing? Willis shows up. I'm like, I know that guy. Yeah. He even shows up. So he finally got court paperwork, as they've been sending him nothing but telling the federal courts they've been sending him everything. And he's not the only one. There are many others listed as creditors that they've done this to. They are lying through the lack of teeth to the court. Now, saran wrap does look like he's sitting in the bathroom again on a toilet.
It's
of
been
course,
nothing but
that would be
fraud
typical.
on her side, and it's pretty disgusting. And they didn't have Travis's legal name.
No.
Just like she's not even using her legal name on some of her court cases.
Wait till we get to saran wrap trying to say who he's representing in the name. It was hilarious. But we're not there yet. Don't spoil it.
Okay.
It's good.
So his hair was a little messy. It looked like he was out in a wind tunnel. But
It
whatever.
could have been.
Maybe it's a new
He
style.
just
that's
woke
coming
up.
in.
On a toilet, George. It could have been a wind tunnel. You got the walls all capped. I mean, if it was one of them small stalls, I like them handicap stalls. I need elbow room. Yeah.
What's it called when someone's head gets plunged into the toilet and they flush it?
That's called
Swirly.
royal flush.
That's what his hair looks like
Royal
to me.
flush.
Yes, for the royalty.
Oh, my beautiful. Yeah. T. Underwood? No, Tug took it down himself because he wanted to. Yeah, Tug took down his stream because there was a few things he wanted to address, so he took it down himself, which was beautiful. It was beautiful that he took it down. Now, Hurricane, I'm going to give you a nice, gentle warning. It's going to be very subtle. It's going to be very nice. And I'm going to tell you, if you want to start an argument, you start up your own YouTube channel and you start an argument with whomever you want to start an argument with here. But you're not going to do it on my platform. And if you continue on, I'm going to time you out. Okay? So just chill your jets, Hurricane.
You got to have a royal flush for the royalty. There's 19 people in the waiting room, and I'm sitting there going, holy cow, there are a lot of people after Lynette's money. Deuce is so dumb. Lynette and Crook have no concept of what he's done to their life. They will never, ever, they have no hope of ever.
Yeah, the level of damage that Deuce has done to him was pretty bad. Okay. I'm going to time you out, Hurricane, because you can't seem to control yourself anymore. you're like a child that just needs to be told how to behave. So, well, we'll just make sure that I reinforce that in the best way possible. Okay. I wanted to play nice with you, but for some reason you just don't know how to be good. It's all right. So what I'm going to do is I'm going to give you a nice gentle reminder that this is not your channel. And I'm going to just give you a nice little timeout. And you can come back tomorrow and relax. There you go. Have a wonderful time. I'm easy most of the time, but you just couldn't behave.
Covering, they will be financially indebted to us for the rest of their pathetic lives.
Yep.
Then there's
He's
20
right.
people, and I'm going, there's more? And at 10:30, when it's supposed to start, now there's 21. Then there's 22, and it's asked to identify themselves, and they say, I'm with Chase Credit. Then there's 23. Randy is now in there, our lawyer, but our other lawyer, Dennis Levine, is in there as well. He is a specialty in bankruptcy, and he also is a specialty in acquiring land from bankruptcy. Then there's 24. Ooh. And then the deputy says, the judge will be in shortly. There are 24 people on Zoom alone. No Lynette. No Lynette. Where's Lynette?
I don't know.
Okay.
Not sure.
Now,
I mean, considering that she's the debtor and she's the one who filed for this frivolous bankruptcy card, she should be there. She should be in the no-no.
I know why Fleesa wasn't there. We made it very apparent in the screen. It's no Fleesa.
Uh-huh.
So.
Freckle Ginger said, thank you, Freckle Ginger, for the $5 super chat. Dang it, Susie. I wanted to play with the gutsy windbag. Now I'm bored. I cannot let my sweet Ginger, get all frisky with the trolls. They get hurt so easily whenever you play with them like that. Doggone it. They get injured, and I can't let you do that, Ginger. No. Dues hurt them all plus paint chips. Kevin says dues hurt them all plus paint chips pitched into. Now all those letters and John Doe filings are sitting in front of Hinkle. Yeah. It's going to be interesting.
The judge does show up at 10:36, and do you recall what she said, George?
She said, we are here today to discuss two motions. The first motion is for homestead exemption, and the second motion to address for damages.
Oh, yes.
And the first thing that came to mind was that Lynette is going after Deuce for damages.
So,
nope.
It's actually Lynette coming after us with saran wrap for damages, because in Levy County Court for the thumbnail case, she was found guilty of a frivolous lawsuit. We were found that we are entitled. It was,
and I will say that the judge and in that suit, and I said it at the time, that judge is being very, very, very careful on the way that he ruled. He wanted to make sure that he followed the rules of civil procedure. And there's very specific things that he could and couldn't do. One of them is he could rule on that sanctions were going to happen, but he can't rule on the amount. And if you read those rules, he's very specific about it, is that they've got, the way they set it up is they say, listen, you can make that ruling, but we can't do any sort of monetary damage. Now, there's the reason, and this actually works out really well for Lynette. What people don't understand is this works out very well for Lynette. And you may think, well, how does this work out well for Lynette? Well, what will happen is if they do it before, for example, if you think about this, they do it before, and the judge, and we'll just throw a round number out there. The judge says $10,000, $5,000 from Lynette, $5,000 from Stark. Okay. That's where the sanctions would be. Okay, so if the judge rules on that right there, and then that ends up going into part of finishing out her creditors. Now, what could easily happen is because the judge may come back, and whenever all of is said and done, whenever it goes back into Levy County, and he's ruling on it there, the judge may come back and say, listen, understand you don't have a whole lot of money, so we're going to put the entire amount onto Stark, and you're just going to have to pay your attorney's fees or something of that. So the judge could change, how much that is going to be. So it actually works out much better for her in the long run if they do rule after the bankruptcy is over. So that way it doesn't get bound up in a whole bunch of shit. So she could come out much further ahead than she did before.
An entitlement here. We are entitled to financial compensation, and no amount has been set yet because of the bankruptcy court.
Yeah, the judge was very cautious and did
like
his
I have
own
a beard.
research with that hearing.
That's the second motion that was
I gotta
being
do
heard,
this.
which we're going to get
I
to
have
what
a
the
beard.
judge had to say, because the judge lit into saran
Redheaded
wrap.
beard.
But
She was not happy.
Yeah.
before all that, she
Like
says,
ZZ Top.
I apologize for the delay. There has been a nationwide outage on the court system, the system that I didn't get it all down. See something, on all of their systems.
She
She
said
MECF.
some abbreviation of letters.
and she said it's just been horrific the past 2 days, and it's a nationwide outage. I was sitting there thinking, oh my goodness, how are they even operating? Everything goes down, and how do we function anymore without computers? Yeah, all the systems, all the information. Wow. So Levine is there, and our hearing starts, and she asks for the counselors to go ahead and identify themselves. And Dennis Levine says, I'm here on behalf of Jeremy Hales. So Ranrap goes, yes, Your Honor. I'm here on behalf of. He can't remember her name. He's stuttering for like 10 seconds. Is it Lynette? Is it Lynette? Is it Lacey? Is it Michelle? Is it Alexis? Every letter was stuttered out of his mouth, and then he finally goes, Michelle. Couldn't believe it. I'm laughing. Our camera has to be on. We're in federal court, and I'm snickering, and I'm thinking, oh, hold it back. Hold.
But can you?
Okay, I'll pause for a second here so we can hit this again. So all I've seen is the judge ruled to dismiss Fed 2. Is that right? No, that's not correct. Okay. And I'll explain what it is for those just joining. What the judge ruled on is he made a recommendation to the district judge. Jeremy has 14 days to respond to what the judge ruled on. And even if it goes in front of the judge, then you have to wait to see what the magistrate actually rules on. 9 times out of 10, that judge is going to take that recommendation. Now, if you know anything about Jeremy, which apparently you guys know much more about Jeremy than I do, but I would assume that Jeremy would probably file an appeal to that. And that's a tough climb. You already know that he's filed an appeal with Owens. So it wouldn't surprise me if Jeremy does file an appeal if it ends up going and Judge Hinkle takes that adoption and rules on it and says yes. So, but other than that, it is still up in the air where that is. So there's no win yet. They could be celebrating early and dancing around in the streets. You never know. What did I miss? Yeah, Shizzy, long time no see. I hope you are well. Bankruptcy for the win. Yeah, the bankruptcy is crazy. It's absolutely crazy.
Blame him. She has so many names. How can he keep up with it?
Can't blame him. And so the judge says, we're here on the 2 orders. We have the objection to the claim of homestead exemption, which Lynette...
Not orders, motions.
Motion. Okay.
Motions.
Motions. I may say things
Wrong.
that are silly at times, but you know, there's a lot of things going on in here. We got a lot of notes written down.
I don't know. There's a lot of marbles rattling
possible,
around
so
in there.
Thank you for the correction.
I don't know. I just have to say there's a lot of marbles rattling around in there because most of the time you can hear him. He just shakes his head. You can hear that tick, 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 tick.
So we're here on two motions. It's the objection to the exemption of homestead. So in other words, what Lynette and Crook are trying to do is save their property. And we have objected to that. They have no legal property because they have no legal homestead. They have no permit, they have no dwelling, and a shed does not qualify as a dwelling. As a matter of fact, in the state of Florida, living in a shed is illegal. Now, so is everything they've done to us in regards to violations of civil protection orders. Think Levy County Sheriff does anything about that?
Crazy.
No. There are a lot of things that are illegal that nobody does anything about. But we're in federal court now. Federal court is not going to accept a tool shed as a homestead.
True.
You should put that on a shirt. Tool shed is not a homestead.
Oh,
That's right,
let me write that
Karen.
down before I forget.
Deanna's off to the side over here. I'm thinking,
Bullshit.
yeah, okay, all right.
Deanna!
She's
awesome.
working on it already. Those may be coming soon. Coming soon in Otter Creek. Tool shed is not a homestead.
Yeah.
And Deanna, so awesome. She came by for my 10K celebration stream. She is absolutely lovely. I enjoyed her so much.
Now remember, Lynette in her bankruptcy paperwork
And the
wrote
ninja.
down and indicated that their camper was repoed in May of 2023.
So no camper.
And then she filed for bankruptcy July of 2023.
So nothing that they can actually live in. They have no permit for the shell of what they call a barnuminium, which is not that. I mean, Lynette even says it's just filled with spiders and scorpions and holes and it's unlivable. Yeah, they don't have a homestead. And again, the most hilarious part of even claiming this homestead, if she would have fought to have Otter Creek unincorporated, she could have fought for all 1.66 acres.
Well, let's go back a little bit. Had she abided by the law,
She would
wouldn't
never
be
even
in
been
mess.
this. Yeah.
Exactly.
Go figure. Huh. Don't break the law. You don't go to court.
We have the law on our side. She doesn't. They've been found guilty multiple times.
So
That
the
is
judge
correct.
says, let's hear this motion first in regards to the objection of the homestead exemption. And Dennis Levine, who represents us and the specialty, he is a specialty. Most lawyers have a specialty. Law is so huge. They have a specialty where they know everything about this and this. Dennis is bankruptcy and particularly land. And Dennis comes in and he goes, listen, this is in an incorporated town. It is more than half an acre. And we think there 100% needs to be an evidentiary hearing set. As a matter of fact, I talked to Saran Wrap last night, and he agreed that there should be an evidentiary hearing. And we had a bare minimum. We need a half-day evidentiary hearing in Tallahassee. Remember what Saran Wrap says?
Well, I want to add on to what Levine said.
Okay.
He mentioned that he needs a final evidentiary hearing in order to produce discovery and needs a rescheduled date of the final evidentiary hearing months from today, and told the judge that he believes they need about a half a day.
So I can tell you, because I already have it, in regards to discovery, there are 44 items that they are going to be requesting in regards to this hearing in discovery, all of which Lynette will never be able to produce.
True.
I'm going to tell you what's going to happen already. They're going to lose 100%. They're already losing. It's guaranteed 1.16 acres. It's already gone. Now, how do you determine which of those acres federal court is going to seize and auction off? And what half an acre do they get to keep? Is it the little corner up front? Is it a corner in the back? You know, if I tell them, hey, I want the whole 1.116 acres in the front on the road, now they have no access to the back of the property, the half acre. Therefore, they can't cross my property to get.
Actually, they can. Jeremy would be wrong in this. It's called an easement, and you can't landlock somebody in. So yeah, and I don't know how it is in Florida, but Jeremy would be wrong in this because you have an easement, you have to allow access to it. That means that they would be able to put in some sort of road to get to their property. If he ended up with all of the fronting property, they would still be able to access. You can't cut off access to somebody's property. The state would step in and force that. I know they would in Georgia. They don't allow you to landlock somebody into property.
Get there, and they're gone out of my life for good, which is the ultimate goal. Don't stalk us. We will make sure you're held accountable if you do. Or do they get the side that has no septic, that has no camper hookup, that has no shell thing? It just has a burn pile and a pile of poop and rotten food. Well, we're going to figure that out. The biggest thing is Saran wrap on the toilet says, I 100% agree. We need a final evidentiary hearing and at a bare minimum half a day.
Yeah, so he did not object to the discovery for the final hearing.
I mean, and as much as I will mock Saran wrap for really crappy filings, he still seems to get some things pretty right. Doesn't mean that he's always right, but he does manage to get some of those things right. He's been, but we'll see how it all works out for him.
Judge goes, well, that was easy. And half a day evidentiary hearing, it will be scheduled no longer than 5 months out. Mm-hmm. And she said, we're gonna file a 2-month status hearing for March 31st to know where we're at in discovery.
I mean, if this happens, then Jeremy can just buy them out, as I doubt that little piece of land will cost that much. That way to be rid of them. I don't know. I mean, they may not want to sell it, or they may just say, no, we don't want to get rid of that. I have no idea. I cannot predict the future on that one. Yeah. Broken clock is right twice a day. That's about like me. Broken clock.
And I thought this was genius because later you're going to find out she dug through all the information on Lynette in the thumbnail case. She knew it all. Mm-hmm. And so she's already knows Lynette and discovery. She's already done her homework. I was shocked. She completely and totally did her homework. Nobody gave her any of this information. Mm-hmm. And she went, 2 months, we're going to have a a status hearing to see where we're at with discovery. She already knows Lynette's not going to send the discovery.
Correct.
And so.
Correct. So, because she specifically said to follow up if there's any issues with discovery. She wants a status hearing to be in the no. Because you could know, or you could no.
Would you agree, George?
If there's any issues with discovery, because there is a pattern with Lynette not turning anything in to discovery.
Except when she wants Fleesa in jail, she literally has all the receipts, all the screenshots, all the proof, which the lawyers have on Fleesa as well. Ooh. I find that ironic. Can we call that karma? Mm-hmm. I got karma to my left.
Well, wouldn't she be intuitive to that and know that beforehand, though?
I got intuition to my left. I got intuition to my right.
We should do a tarot reading.
Oh, no.
Guilty, going to jail. Guilty, going to jail.
That's the card of Fleesa behind the stand with her right hand raised like this.
Oh,
and then you see perjury.
You literally think she could raise her hand that high?
Ace or Frank Otter.
I don't think so, George.
She feeds herself somehow.
Okay. So we then immediately transfer over to the second motion. Mm-hmm. Now, the second motion is Saran Wrap and Lynette want the stay applied here in Levy County on the thumbnail case where Lynette was found guilty and Scott Stark's estate
be safe
was found guilty of filing a frivolous lawsuit, then dismissing it, and we have been found, would you call that, what's the opposite of guilty? Innocent, but no, We have been found.
We won. I mean, we won.
Winners.
We
We're
proved
winners.
that she brought a frivolous
Yes.
lawsuit against us, and we had to hire an attorney to defend us because we knew that the law was on our side and we didn't violate any laws, and the courts agreed with us.
They have to pay us. They have to pay Larry Foreman, who, by the way, is still a very close friend, even though he's not covering the case per se. Very, very close. We think Larry and Chandler are the greatest. Gonna have to pay Tat. Gonna have to pay. Geez, who else was in
Me.
that? Oh, you were in that. Oh yeah. There were some others in that too, but we're talking tens of thousands of dollars.
Well, they smell good.
Lynette will be liable for 50% of it, and Scott Stark will be liable for 50%. So Saran Wrap files a motion and says, no, this is illegal. This goes against the federal stay, and we want money from Jeremy Hales. That's what their motion said. Yeah. They tried to get money today in bankruptcy court. But now, obviously, she's laughing. You can see what's happened. Now, I will share this with you. The judge rips into Saran Wrap like 15, very politely, but extremely sternly, rips into him for like 15 minutes. So,
and we've seen this happen before. We've seen this happen with the judge before. This, the judges tend to correct him whenever he's absolutely wrong. We saw that whenever he made some pretty crappy filings. I've still got that stream up where, you know, it's really interesting. With, I think it was the sixth district. We may have to watch that again because that was so much fun. Oh my God. I just about split myself in two whenever I saw that. Whenever I saw that. Oh my gosh. That was so good.
The judge says, all right, Saran Wrap, what's the deal here? Saran Wrap says, well, Your Honor, we feel that the motion speaks for itself. This guy is hired to argue why his motion is legally correct. His defense is the motion speaks for itself. He finally gives her a little bit more information. He says on December 17th, Levy County held a hearing and stated and found that Jeremy Hales, Martha Risk, et al., that means all the other participants, again, Larry Foreman, Tat, they are all entitled to fees. And Saran Wrap says, we believe this is fundamentally violates the stay. And we ask the court to void Levy County's decision, and we want legal fees.
Yeah, the judge, I can tell you right now, the judge didn't have any of that. Because if you read what the filing was and you read what the law was on that particular one, that was a very, very, very well pled argument, because even the judge said, I'm not going to rule. I'm going to rule that you win, but we're not going to rule on monetary damages until after the bankruptcy court. And it was absolutely, absolutely beautiful. It was absolutely beautiful.
For damages.
For damages. Damages, emotional, inflicted, you know.
On a lawsuit that his client brought on us.
Yeah.
That she voluntarily dismissed.
How many times now? Oh, Deuce, you're so smart. You're so smart.
Genius.
IQ
genius.
Namaste, Deuce. That's Saran Wrap's defense. The motion speaks for itself. We want you, this violates the stay, and we're asking the court to void Levy County, and we want fees. That was his whole defense.
That's it.
The judge goes, all right, Mr. Shockett or Mr. Levine, who's got something to say? Randy goes, I'm going to take this one. Randy says, hey, Judge.
Good night, Mary Boyle. Good to see you.
You just heard the exact opposite of what the law actually states. And I'm like, go, Randy, go.
Randy was on fire.
He was on fire.
He was on fire.
Randy was on fire.
I didn't pay attention to the tie he was wearing though.
Oh,
I should have.
Deanna,
you
there's
probably
somebody
should've.
out there. They're supposed to be here? Okay. All right. I'm sorry. Security is a major issue here.
Absolutely.
I apologize. So Randy's on fire, completely and totally on fire. And he lays it down, and I love it. And he goes, Lynette brought this action. She initiated the action as a debtor. And the action is against her counselor as well, Scott Stark's estate. Just because he died doesn't mean he gets out of this.
No.
When you do something illegal, your estate is now held in contempt. Now, the funniest part is his now widowed wife keeps bragging that she's going to be a millionaire this month. She is all over threads stating, you ever met a millionaire? Well, talk to me on this date. She's literally out there stating she's got all this money.
No problem, MQ.
Thank you. I mean, that's going to be used in court as well once we get the actual final judgment. So Jeannie Stark's going to have a rude awakening when she finds out she's 50% liable. We've already been found 100% legally entitled to the money. And after the bankruptcy, then there will be the hearing on how much money. She will not be able to wipe it away. She will not be able to set it aside with bankruptcy. It will 100% be in effect. And if she doesn't pay, there's going to be some major issues.
Well, let's not forget, Jeannie Stark is the one who took the phone call from Deuce. She's the one who writes all the motions, and she was 100% in from the beginning up until the end.
So Randy goes on to state, listen, this is the law. You can't use bankruptcy as a sword and a shield. So you can't go attack Jeremy Hales with a sword and poke him and poke him and poke him and go, I'm suing you for using my image, which, by the way, I own the image. I took the pictures. They're from my public videos that I took of her in public. Therefore, I am the owner of that image. And she wants to sue me and then go, uh-oh, I'm in trouble. I'm going to be found guilty and I'm going to owe Jeremy money. Now I want to use bankruptcy as a shield so Jeremy can't sue me back. The law doesn't work that way.
No, it doesn't.
She initiated the lawsuit, and trespass 5, the same is going to be for trespass 5. She initiated thumbnail, trespass 5. She's initiated so many ridiculous things from the most horrific legal counsel she has ever gotten, from Deuce, from paint chips, from vomit, from lips, the hoe flunk of them all, from Fleesa. Yeah, that AI is really going to help out there. So she has been found guilty. We've been found entitled, and there will be a monetary amount. And Randy says, Judge, we ask you to completely and totally deny their motion. Jeremy doesn't owe them anything. The courts have already determined she is going to owe him money. He's entitled to the money. Okay.
Yeah. And to add to that, there was a point where her bankruptcy was dismissed because Saran Wrap failed to turn in paperwork timely. So there was a lapse. So during that lapse is when the initial filing was submitted by Randy. And that's what got us the hearing, because her side failed. Remember?
And she can't get out of it.
She can't get out of it. So Randy made it very clear that their motion mischaracterizes what truly happened, and then talks about how his motion, the stay is not subject to an automatic stay. His motion is, or the pleading was not subject to automatic stay. The actions are against the debtor who initiated. She's the one who initiated the lawsuit.
Yes.
And then he
can't go out and attack people and then cry victim, is basically what the law says. Now, that's what you've seen with every single one of the Anti-Wth ecosystems. They've attacked us. They have broken the law. They have not remained within protected speech. Let's say this is the circle of protected speech. Your First Amendment right. It's protected speech. You get outside of it, now.
Well, and Bolitho disagrees with Jeremy on this. Just so you guys know, Bolitho thinks that they were totally within the realms. Well, not necessarily. That's not the way that it works. The way that the Bolitho ruled is saying that the pleading wasn't sufficient, is what Bolitho basically is saying in that pleading. So, and if you don't believe me, you can go back at the very beginning and read exactly what Judge Bolito says. He says that this pleading wasn't sufficient to meet the standards that was required to meet X, Y, and Z. And so whenever he did that, he said, okay, you did not meet these thresholds, and it requires much more. And he's not giving them any extra opportunities to amend the complaint. He was very specific in that, saying, I'm not giving you any opportunity to amend that complaint. I already gave you one shot at it and you didn't do it correctly. So we'll see. We'll just watch and see what happens over the next, 14 days. There's 14 days before we'll see what Randy files. And it might cure that. I don't know. We'll see. We'll just have to wait and see. I cannot read tea leaves, unlike some other people think they can.
You're legally liable. And they cry victim, and the law goes, no, they are the victims. You have victimized Jeremy Hales and George and others.
Mm-hmm.
So,
and they keep weaponizing all these different ways to try and make us look like the bad guy when they're the ones who initiates everything.
So the federal judge says the saran wrap. Anything else you want to say?
She asked him, do you have a rebuttal?
And he goes, this claim undermines the state, as he's sitting on a toilet with, looks like he was just dunked in.
Hey, Linda.
I get a swirl.
Good to see you.
I
Welcome.
think it was pushing too.
Oh my gosh.
And at this point, the whole courtroom takes a drastic change as she lights into him.
Oh, this is
for
where she's on
15
fire.
minutes. 15 minutes. Now, I want to say that Lynette has been yelled at by a lot of people. The trustee in bankruptcy, the Ohio judge, and we've witnessed all of this, depositions. This judge wasn't yelling. She was very stern and to the point. And don't you bring this garbage into my courtroom ever again to Saran Wrap. Let me be very clear. This was all directed to Saran Wrap.
Yes.
Okay?
Ooh.
So the very first thing she says is this motion is.
And of course, I can't wait to actually see that, because that, you have to understand, those are recorded and Jeremy can FOIA those. Now, I don't think that I can, but I think that Jeremy can FOIA those. And after all of the bankruptcy is over, he'll be able to show you exactly what happened. Did Saran Wrap go to the same law school as Lips? Possibly.
Denied.
Denied.
No, I don't think he did.
Boom! That's another big win for what the Hales. So in other words, Lynette 100% will be paying, and Scott Stark's estate will be paying. Our very first thing she says is this motion is denied.
Denied.
That's all that matters.
Boom! That's another big win for what the Hales.
I'm good at doing the pause face.
So in other words, Lynette 100% will be paying, and Scott Stark's estate will be paying ourselves, Larry Foreman, and others. Okay.
Yep.
Do you want to go into some of the things that the judge said to Saran Wrap?
So yeah, she did. The first thing she said is, I'm going to deny the motion for damages, and then goes into why she's denying it. And you could tell she took the time to read it and do the research prior to today's hearing.
I do want to state one thing right there. She very clearly stated that this was a complete and total waste of time in this hearing, and we should have never even been there today. And this is where she blew me away. She did so much homework. She did all of the investigation beforehand. Deanna, you can just walk behind us. Deanna's trying to be polite and not go in front of us right now. She did all the investigation beforehand.
I would get in trouble.
She knew everything, and we didn't even have to say anything. It was mind-boggling. I'm like, holy cow!
Yes.
Like, she's got to be so busy, and yet at the same time, this is all going, and she's just ripping it off like boom, boom. This was filed in Florida, and this, and this, and then this happened, and then this was dismissed.
Yes.
All right, you take it away from there.
These types of hearing typically have a window of 10 to 15 minutes tops. And we were in there for
Almost half hour.
yeah,
Oof.
a little over half hour. And at this point, she was just so annoyed. And you could tell the frustration in her voice. And she said, the creditor is correct.
That'd be us, Randy.
That would be us. That our motion in regards to his motion for damages, like, we're correct. And that there can be proceedings against the debtor, which is Lynette. She verifies that, yes, because the debtor, who's Lynette, is the one who filed and dismissed on the day of summary judgment hearing.
The eve, she said, the eve of the hearing.
Summary judgment hearing.
And she went off on that. She's like...
She was even shocked that that even happened. Like, why bring a suit and then the eve of dismiss it?
Yeah.
She was upset.
And do you want to add anything else to that?
No, go ahead.
Okay. And she even addresses that the state court, which is Judge Grobe out of Levy County, was very cautious and didn't determine an amount. He did not determine an amount.
She did her homework. She went through everything. We didn't give it to her. She came prepared. I couldn't believe it.
It was pretty impressive. I loved every minute of just hearing her. She's very educated.
Bankruptcy judge
She's
is
well spoken, and she goes on to say that the state court, when we say state court, we mean Levy County, the county court, did recognize that there was a bankruptcy case. It's all in writing. It's all in writing. Ramsaran tried to make it sound like we were sneaking and doing it behind the backs of the bankruptcy court. And
well, no, it's even more than that. There was no case. It wasn't that he was, I mean, he was competent enough to file it. It wasn't that he was unprepared. But the problem is if you go through and you read what those pleadings are, they couldn't even pass. And they were so poorly written. I mean, it was like amateur hour as far as Florida rules go, as far as anything that was brought on that. It was so bad. It was so bad that there was no case, and they were about to lose. I mean, there was no doubt that they were about to lose, and they were just like, we need to get out of this thing. Even Stark did not want to be representing her anymore at that point in time. It was that bad that Stark was, because we've gone through his deposition. He was just like, I have no idea. I have no idea. There's this other attorney that's writing this stuff for me, and I'm just signing off on it. He never read what was being filed. He just signed off on it, and well, he got himself in a shit ton of trouble. Good job, Stark.
Recognizing that the stay does apply, I can't read that part of my writing, and then talks about.
Well, hopefully she's legal. And did she shave beforehand?
How the bankruptcy, it's not the bankruptcy's court's job to go behind the state court when it was already respectfully done by the creditor. They can't, what she was saying is they can't go behind the other judge's decision. It's not their job to do that.
Correct.
Which was the first thing I thought when I first saw that motion for damages that Lynette and her attorney filed. I'm like, how did they have even jurisdiction over that?
She was very clear that she would never undermine what the state court did, and the state court did everything respectfully and correctly and right, and Saran Wrap did everything wrong, and she was throwing it in his face. And this is the funny part. How many times do we have to win and win and win for the antis to actually realize they're done? Everything they try and propagate out there, they try and throw out, it's propaganda. It's all lies, and it all fails. And eventually, they're all going to have criminal charges.
Yeah. So then she basically tells Saran Wrap that we have the right to file that. We have the right to file that motion for sanctions, which again, an amount was not determined. It basically states that we are eligible for entitlement.
And she says that the state will determine the fees that Lynette will be paying after the bankruptcy is over. This will go forward. This will move forward. And then she's got questions. She's like, I find it rather interesting that Lynette Preston didn't show.
Ooh.
Not only that, the counsel for Lynette Preston did not show.
In Levy County that day. Yeah, she did say that.
Ooh.
She goes, therefore, the debtor did not suffer damages
Ooh.
because she didn't appear.
Ooh.
She's like, there's no even damage. She didn't even appear. The person that was damaged is the creditors, which is us. Which is us.
And then she goes on to saying that this motion was not a willful stay and denied the fees. And then this part I loved. Then she focuses her attention from Ramsaram to Levine, attorney Levine.
Our attorney.
And she tells him, next time, just file a motion for stay. We've wasted so much time.
Stay relief. So
Yeah, stay
she's
relief.
so mad at Saran Wrap. She's so upset. She did all of her homework. His defense was, we believe the motion speaks for itself. This undermines the federal stay. We want money. How much are we going to get? And she looks at Dennis Levine. She goes, next time, just file the motion for stay relief, and we don't have to do all of this garbage.
Yeah. Oh, nice.
She was not happy
at
that
all.
This motion for damages
At
on
all.
Ramsaram was even entered into her court.
Now, here's the thing you have to think about.
Ooh.
They've already upset this federal judge in bankruptcy court. She's beyond upset with Saran Wrap and Lynette. She's in complete and total disbelief that Lynette and her counselor didn't even show up for the thumbnail case.
Here in Levy County.
How do you think the rest of bankruptcy is going to go for Lynette and Saran Wrap?
My guess, no bueno.
No bueno.
Ain't looking good in the Otter Creek hood.
And there you go. There you go. Yes. But we do have something for you that might make your life more enjoyable before we head out and we go spread the love. Here you go. Just for you guys. Enjoy.
No camera on, just a breathing mic. Static wheeze, in the midnight fight. Ellie be home, grease in the air. She hits the stream alone, nobody there. She's running to the jail like it owes her money. Skin on skin, only baloney, sweaty tube chins, harmonizing with she in hair stands like a leak with choking on nails. Grease ghost cream to the carpet bow. Every breath smells like sport denial. Keyboard shining, keys one fat from raised top of lies and any through cats. Paper play bros and the poetry crimes. Came folded up like a greasy shrine. She smacks her lips, talks through teeth. Tooth drown slow beneath the grease.
Chicken skins and cigarettes.
Greasy jaw and no regret.
Crunch out enough to stab a dog.
Smoke thick like a brain they fall.
Chicken skins and cigarettes.
Even the cricket left in distress. Ashtray overflowing looks like a swamp. Filters crushed like boundary stomps. She flicks one brown, likes another rest out in the mix she's never met.
Oh, brother.
Grease slides wrist to the elbow bend. Shirt stretched in, wipes hands again. Burps mid-sentence, keeps on going. Hate gets louder the less she's known.
Chicken skins and cigarettes.
Greasy joy and
No rebate.
a dog bows down our hall. Smoke so think the thoughts just stall.
Chicken skins and cigarettes.
Cricket packed up, said screw this, and left. Yeah, catch his breath while climbing stage. Grease is popping out of frame. Yeah, they all lies. Static laugh, she hacks and stays. Grease is stand step beside the mic. Evidence over beers and knives. She all just swallows, clears a broke. Them flies off a bullshit quote. Claims receipts shows none, just sound. Confidence loud, facts drown. she chews, harder is to pull it. She slurps and sucks down the gullet.
Chicken skins and cigarettes.
Reese and joy.
No regret.
When you hack my clips, all of your red smoke so dense it kills the bread.
Chicken skins and cigarettes.
Even the silence sounds upset. Oxygen then weaves between each word. All glums like it's filing a grievance heard. Axe cough slow on bleeds with hands. She wipes them off on her head. Lips smack, cough, swallow, lies. Same sentence, different fried. Room smells like burnt fat and spite. She hacking, coughing through the night.
Chicken skins and cigarettes.
Grease and joy.
No regret.
I touch it like bone, getting a trash talk back the.
Breeze so deep, it needs your lecture. Chicken skins and cigarettes.
Chicky laughing no. Yeah, can't help this play. Chicken skins and cigarettes. Crazy joy and no regret. When you're gone like a dog don't fail. Both so big, the balls are more. Chicken skins and cigarettes. I don't even that's all get tech to stress. Smoke hangs low where the ceiling cries. Grease still warm, truth still lies. Heartbeat thoughts with the detector. Red lights bling like a bad brain. She won't shut up, won't let go. She telling secrets she don't know. Last drag burns, lungs protest. Skill chewing through the grease and mess.
Chicken skins and cigarettes. No regret. No regrets. No regrets.
Everybody, I want you to have a wonderful evening. Don't fret it. It's almost just about done. I'm going to send you guys over. Go see the Broken Baker. Send him your love and throw a little bit of bacon up there. You know, just to give him a hard time, or some biscuits. One of the two, because I know how he loves biscuits. Maybe some cream cheese. Yeah, some cream cheese always drives. Maybe some Danishes. Everybody have a wonderful evening, and I will see you tomorrow. Peace, everyone. Peace.
Thought I was done, bless your heart, but I'm still living rent-free, it's a work of art. Call me daddy, call me Papa Nut, call me the GOAT. You're paddling upstream while I'm running this boat. You say, I don't care, yet you're glued to the screen. Bathe in my glow, you're so unclean. Your shade like a breeze, it's barely a draft. I'm the Picasso of roasting your ass. You say you're over me, oh how cute, but here I am, still the star of your loop. You're my biggest fans, don't even deny. So grab some popcorn when daddy goes live, 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 live. Call me daddy, daddy, daddy. Yeah, shout it loud. You're a mental midget while I stand proud. Papa Nut, Shizzy, daddy, headline act. Your background noise and it's just a fact. Call me daddy, daddy. Let's face the score. You hate that you love me, but you keep wanting more. You're like a dog chasing cars, you don't know why. You don't know why. But here you are barking while I touch the sky. While I touch the sky. Your comments are gold, such comedy gold. Who hurt you? Oh wait, it's me, I'm told. You're keeping tabs like an unpaid intern while I'm cashing checks. When will you learn? Your timeline's a shrine to every move I make. I'd say thanks, but you're a nasty skank. Oh, Shizzy's washed up. Yeah, sure, Jan, yet here I am, the centerpiece of your plan. You hate, watch my stream every damn night. That's why, kiddos, I'm still shining bright. Call me daddy, daddy, daddy. Send in your bread. I'm living rent-free in your effing head. Papa Nut, Shizzy, daddy on your brain. I'm your mental landlord, you wanna complain. Call me daddy, daddy. Let's keep it real. You hate that I'm winning, but you love how it feels. Oh, I'm sorry that I break your streak. You tried to ignore me for like half a week, but daddy's too spicy, you can't look away. I'm the train wreck you need every single day. So while you're out there rich, you're trying to chase cloud, I'm here sipping coffee, watching you freak out. You're irrelevant. Wow, what a take. Now go rewatch my vids and I count how much I make. Call me daddy. Yeah, own it now. I'm rent free your brain and you don't know how. Papa Nut, Shizzy, daddy, let's set the bar. I'm bigger than life. You're a burned out star. the main character. You're just a troll. So here's your bedtime story, kids, sweet and snug. Shizzy daddies forever if you're stuck in the mud. Now say goodnight to Papa Nut, your mental king. Oh wait, you will see me tomorrow. Same obsession, same thing. Call me daddy. Yeah, own it now. I'm rent for your brain and you don't know how. Papa Nut, Shizzy daddy, let's set the bar. I'm bigger than life, you're a burned out star. Call me daddy. Embrace your role, cause I'm the main character. You're just an old raggedy ass burned out troll. So that's your bedtime story, kids tucked in sweet and snug. Shizzy daddies forever, you lose and you're stuck in the mud. Now say goodnight to Papa Nut, your mental king. Oh wait, you will see me tomorrow, same obsession, same effing thing.
Right, everybody, you have a wonderful, wonderful, wonderful night, and we will see you again soon. Peace, everybody.